Right. Am I audible?
Yes, you are audible.
Okay, start recording. Just one more minute. Bhuvan is also joining us. Just 1 minute. Is my screen visible? Can you see my screen?
Yes, yes.
All right. Thing with copyright is this time it is very obscure, very abstract, and very unstructured. Okay, I've tried to restructure the classes, combine all the similar topics, and I'll try and deliver it now. Just try and follow along, okay? And every section we'll stop, take doubts. So try and understand every concept perfectly. Okay, first topic we're going to cover is orphan work. And this comes under section 31A. We'll see what the section says. So let's say there's a book that was published in 1970. Okay, only the first edition has been published. That's it. Then the book has gone out of publication. The right holder, who's the right holder? The publisher or the author of the book, correct? And the author has given permission only for the first edition, so you cannot publish it again. And the book is withheld from the public for a very long time now. It's 2022, right? Nearly 50 years over. Now you want to publish this book. How will you do it? You'll have to find the author, right? Because the copyright subsists. Copyright subsists for 60 years following the lifetime of the author. So how will you publish this now? So you conduct a due search to find the author or the publisher. And you find out that this publisher does not exist today. The company has gone out of business and the author is untraceable. So how are you going to publish the work now? Now this work is something called an orphaned work. Because the work has no parent now, right? But you put your due diligence to try and find the parent. So what makes a work as an orphaned work? When there is no author or right holder, and after taking due diligence to find the author and right holder, you have still not been able to find it, right? So that is what an orphaned work is. So can you publish this work now? Yes, under section 31A, this is called the orphan work licensing system in India. And what does 31A state? It says that any work published or communicated to the public and the work is withheld from the public where the author is dead or unknown or cannot be traced. Okay, so you have to put some effort to find the author. Then the owner of the copyright in such work cannot be found. Then the applicant, in order for him to be able to publish it, should publish his proposal in one issue of a daily newspaper, accompanied with a copy of an advertisement, and he needs to get a license granted from the registrar of copyrights, as in from the court, the copyright court, right? And the applicant has to deposit the amount of royalty determined by that court in the public account of India or in any other account specified. So what it actually means is, now there's an orphan work and you want to publish an orphan work, right? There are three things you have to do. First one, you have to publish this whole proposal in a newspaper, which everyone is bound to read, okay? Second one, you need to put an advertisement in that newspaper saying that you're going to be publishing this orphan work. Third one, you need to take out a separate bank account and deposit whatever royalty was supposed to be given to that author in that bank account. Why do you do this? Suddenly, if the author pops up someday, he suddenly shows up randomly on your doorstep, all the money in that account can be given to the author. Okay, these are the three things that you need to do. So as to enable the owner of the copyright, or as the case may be, his heirs, executors, or the legal representatives to claim such royalty at any time. So these are the three things that you have to do as per the section. We'll go over it again. So let's say there's a community called the GLAM community, okay? Galleries, libraries, archives, and museums. So all these are collectively called as the GLAM community. And GLAM, you know, right? Libraries have such large amounts of copyrighted material. They have so many books, files, documents, photographs. So let's say there's a museum or a library, and they have to find the right holder. They have a book which they want to publish now. They want to circulate it to the public. So they try to find the right holder. And he is untraceable and unlocatable, right? So it is an orphaned work. And copyright is still subsisting on that work. So you cannot republish it without violating the rights of the right holder, right? Under section 14. So what can the library do now? What can this GLAM community do to publish the work? There are two methods, okay? First method, section 31A, where you use the orphaned work method, where you put a public notice in the newspaper, given an advertisement, then you need to deposit royalty in a separate bank account after the royalty rate is determined by the what is that place called, man? By the appellate board. It's called something else now. It's called some court now. What is it called? Any of you remember? No, some court. The appellate board got renamed as some other court. Any of you remember? Commercial court. Yeah. Okay, so whatever rate the commercial court sets as the royalty, that amount has to be set aside in a separate bank account. Okay, so these are the two things you have to do under section 31A. There's one more route, okay? One more route they can do is under section 52(1)(p) called the fair dealing doctrine. So under that route, they can reproduce the work at a time more than 60 years from the date of death of the author. This is kind of obvious, right? The author has copyright over the work after the lifetime and 60 years following that. So once the author has died and 60 years has gone from that, you're free to publish it, right? So what I'm trying to convey is, I'll summarize it. There are two methods now if you want to publish an orphan work. First one is under section 31A, where you need to do these two things. A public notice has to be put where you deposit royalty in a separate bank account. Second route is under section 51A, fair deal doctrine, where you wait for the copyright to end 60 years following the lifetime of the author, then you go and publish it. Okay. So what is all this nonsense I've written here? You remember in second test, I told you that there are three conventions: Barnes Convention, TRIPS Agreement, and then the UN Convention on Copyright or something, where you can put restrictions on the rights of the copyright holder, but you can't put too many restrictions. There are three conditions that have to be fulfilled. First one, is it a special case? Yes, it is a special case because it's an orphaned work and the author is untraceable. Does it unduly prejudice the author? No, it does not, because the license fee has been fixed by the commercial code, correct? It is something fair. It's not something that is going to harm the author. Third one, is it interfering with the normal exploitation? No, because the author does show up, he's free to exploit it in his own way. So these are the three conditions that come under these conventions, and all three are followed. So the orphan work regime is legally binding. Okay, it exists in every single country in the world. So moving on. So what were the two routes I told you? Under section 31A, the orphan work licensing route. Second one under section 51P, the fair deal doctrine, right? So therefore, the library has to wait for the copyright to expire. So both the routes are open. Section 31A route, the compulsory licensing route, the orphan work route, and section 52P route, the fair dealing doctrine route. Okay. And the exact correlation between these two is not established. Like we've already seen, the Copyright Act is not something that has been dissected in court yet. And these issues, there's a lot of ambiguous jurisprudence regarding all of this. Okay. So if it is an unpublished orphan work, the author's location is unknown, right? Because you're not able to trace him. So this customary royalty has to be, is it required or not? Yes, it has to be maintained in a separate bank account just in case he shows up. Perfect, right? Moving on. This is the first concept. Have you guys understood orphan work? Any doubts? Very simple, na? That's all. Okay. Second one, this Google Books came up, right? There's this website, there's this initiative that Google started called Google Books. What they used to do was, they used to upload copies of books online, just a few pages, not the entire book, just around 10 pages of a book. And on the left-hand side, they used to have links to purchase the books, as in to Amazon, to Flipkart, to the actual books website. So they were doing this. And what did the authors come and say? They came and said that this is copyright infringement. Google has no business uploading our books, right? But what do you think? Is this copyright infringement? No, because what did the court say? The left side of the Google Books interface, only a few pages are available. It's only a snippet view of the book. And on the right-hand side, the libraries and the e-commerce websites are available as to where you can buy the book. So is this copyright infringement? And what did the court say? The court said that it was a fair use. Okay, the courts held it as fair use. Okay, and Google is not giving the entire book. It's only giving a snippet of the book, and it's directing the customers to the correct sites. Okay, it is following the rules. It is not infringing copyright. This is something Sir stated, something separate. I just gave you guys the concept on Google Books. Okay, moving on to the next topic we're going to cover today: performers' rights. Who are performers? Suppose I'm shooting a film now. I'm going to direct a film. The actors are the performers, right? So we're going to discuss what rights do they have. Does an author have right under copyright? And the regulation, international regulation regarding performance rights is called the Rome Convention. It is not completely adopted by India. Okay, India has not completely adopted it, but the principles apply. And what are the sections under the Indian Copyright Act? Section 38, 38A, 38B, and Section 39 are what talk about performance rights. So what does Section 38 talk about? Performance right. Okay, it defines the right. Section 38A talks about the exclusive right of performance. As in, performers have two rights, dual rights. They have a right to the sound recording of their performance, and they have a right to the visual recording of the performance. And they have the right to reproduce, communicate, sell, distribute, all the rights under Section 14A, under Section 14. Okay, so they have dual rights. So let's say there's a snake charmer. He comes to your locality and he does a performance with a snake. And you take a video of his performance of 10 minutes and you upload it on social media. Now the snake charmer can take you to court. Why? Because he has all the rights under Section 38A. He has two rights. He has the dual rights of sound recording, and he has the right of video recording, the visual recording of the performance. Right? So he has the dual rights. And now that you have uploaded it, you have violated his rights. So he can take you to court. So now when Mathilal sir gives a lecture, SM has dual rights, as in the sound recording of his lecture and the visual recording of his lecture. Also, he has one more set of rights, where all the words that are spoken, the transcript of the entire lecture is also considered as a literary work, and that is also protected under copyright. So even he has a literary work. So SM has all the 38A and 38B rights, the dual rights, and rights under Section 14 for the transcript of the lecture. Okay, Section 38B talks about the moral rights of the performer. We'll see what moral rights are. And Section 39 talks about some nonsense. We're not even going to cover it. So there are two types of performances, okay? Classical physical performances, as in where you see the live performance in front of you, live drama. and digital performances that you see on a screen, YouTube video, movies, all that. So classical performances are covered under the Rome Convention. Digital performances come under this WIPO Performances and Phonograms Treaty. Okay, and the definition of performer, as defined under Section 2 of the Copyright Act, does not include cinema extras. As in, there's a scene going on, there's a fight scene, and there are two people in a juice shop at the back. They are cinema extras. Okay, they do not come under performer. That means they are not entitled to any of the rights, including the moral rights. Okay, so what is a performer's license? So I'm an actor, I'm a very famous actor. A producer has come to me to act in his film. When I act in his film, I have the performer's license. I have to grant him license for him to be able to use that scene, right? Because I have both the dual rights under Section 38, the right to the sound recording, the right to the visual recording. So I have to grant performer's license to the producer. So whenever a performance is incorporated with the sound recording, the license of the underlying performer is required. And what is the scope of this license? Okay, there's a performer in a film. He gives consent to a producer after taking 2 crores. He's a very famous actor, so he takes 2 crores. He gives him permission. Does he still have rights after giving the license? This is the question, okay? And what does Section 38A state? Once a performer has consented to the incorporation of his performance in a cinematograph film, he shall not object to the enjoyment by the producer of the film of the performance right in the same film. That means once I've given my right, it's over. All my rights are extinguished. Okay, once the performer is offered his consent, all the rights have been extinguished. Provided that notwithstanding blah, 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 performer shall be entitled for royalties in case of making the performances for commercial use. What does this mean? It means that when I use the film, when I use that recording, the video of the actor for some non-intended purpose, something beyond the intended purposes of communication. I think you would have remembered this from Section 17 or 18, right? When I use, it's there in my PPT. 1 second. Last 2 slides. Yeah, so under Section 18, it says that whenever I use some work and I use it for something beyond the intended purpose of communication, let's say we shoot a song, okay, all of us, we write lyrics, we shoot, compose music, and then we record a song. Now, when I use the song in a film, that is the intended mode of communication. But when I use the song as a ringtone, I sell it to a company that uses it as a ringtone, right? Or when the story of my film is adapted as a TV series, then it is being used in a non-cinema exploitation. It is being used beyond the intended communication of a public. In that case, there's something called the equitable remuneration doctrine. As in, all the royalty that is derived from some extra source, all that has to be equally shared with all the others. So the question that we arise here is, when the performance it's used for something beyond some other commercial use, beyond the film, does the performance also get royalty? The section says that, okay, the section is saying that the performer shall be entitled to royalty, but the case laws say that they don't get royalty. So this is the confusion that exists. What it says is, if he has consented, he cannot further object, okay? As in, if once he has granted his license, once the performer's license has been granted, he can never take it back. Rights have been extinguished. If the clipping is shown outside the film in some other purpose, as in some WhatsApp video or some YouTube video, does the performer get royalty? According to the proviso, according to this section, it says that the performer shall be entitled to royalty. But what Matilal sir said is, and what this film case said is, Fortune Films versus Dev Anand, it said that once the actor has already received money, and even though the performance is used beyond the intended purpose of communication, the Supreme Court held that once the performance is incorporated, you cannot claim further rights. All your rights are extinguished. Once the performance is incorporated, the producer has an uninterrupted right on the performance. But even though the proviso says that the performer is still entitled to royalties in case of some kind of commercial use, it does not exist because the case law says the opposite. So there is a confusion. And what does Matilal say? He says that the proviso is meaningless. It does not make any sense. And there cannot be equitable remuneration doctrine in performance. It is always ex ante royalty. Ex ante means where you pay them beforehand. Ex post royalty is where you give the royalty after the performance. But here you're paying the actor, right, before the movie releases. So in ex ante royalty, equitable remuneration doctrine does not apply because the performers are paid beforehand. So this whole proviso under Section 38A, provided that performer shall be entitled, it's completely meaningless. Okay, it does not hold substance. That's what sir said. Moving on to moral rights, we'll finish this and I'll take doubts. What are the moral rights of a performer? It says that all the performers shall have the right to claim to be identified as the performer of the performance. As in, once you finish the movie, you see the names, right, in the credits. So once the performance has been done, they deserve to get credit for their performance. And B, to restrain or claim damage in respect of any distortion, mutilation, or other modification which is prejudicial to his reputation. So you cannot take his work, any performance, twist it, add some sound effects, and make something that is prejudicial to his reputation. These are the 2 moral rights they have, and there are 2 names for it. First one is called the right to parenthood, as in where the performer has a right to be the parent of the work. and right against mutilation, where you can't distort what he has performed and make it against his interest, right? And what is the explanation? It says that it qualifies it. It says that mere removal of any portion of a performance for the purpose of editing, where you just cut his acting just to fit in some kind of time, to fit the recording within a limited duration, or any other modification required purely for technical reasons, will not be deemed to be prejudicial. So normal editing does not come under section 38A or B, 38B, clause A or B. Moral rights don't infringe on that. Normal editing, it does not come under it. But if I have an actor, I've acted in a film and the producer does not put my name at the end of the film, then it's violating my right under clause A. Or if he takes my acting and he makes it into some kind of comedy, some kind of satire, and he publishes it, which humiliates me, which mutilates my reputation, which damages my reputation, that is also violating my performer's right, my moral rights of the performer. So these are the two rights they have, okay? Right to parenthood, as in to claim ownership of the performance, and right against mutilation. And, yeah.
Just explain again these two rights.
Yeah, 1 second. So what are the moral rights that a performer has? Two sets, okay? One is right to parenthood, to claim to be identified as the performer of his performance. I've acted in a film. At the end of the film, actor's name, my name should come. I have that right. It's my moral right. Second one, to restrain or claim damage in respect of any distortion, mutilation, or other modification which is prejudicial to his reputation. So once I've performed, as in I'm a snake charmer and I've performed some snake video, someone has taken it, added sound effects, they've distorted it, as in the producer has sold the license to, and then he's releasing it as some comedy video. He cannot do that because it's violating my right under section 38B. So these are the two moral rights I have. First one is right to parenthood. Second one is right against mutilation. But what does the explanation say? It says that mere editing, just where they just cut my performance to fit it within a limited time or some other technical reason where it has to be trimmed, that is not prejudicial. Okay, so that is allowed. Moving on, there was just one case that's not related to moral rights, just rights of the performer. There was an actress called Kajal Agrawal. I've given the link. So if this case comes or something similar to this, you can always find the case over here. She had acted in a commercial for hair oil, okay, in 2008 or something. And she had put a clause in the contract which said that the producer will be able to play this ad only for 1 year. She had an agreement with the producer, the ad will be telecast only for 1 year, but the producer obviously kept playing it even after 1 year. So she went to court. And the court held that all the performer's rights were extinguished. The second she signed the contract, her rights were all extinguished. And the producer has all her rights. Okay. So if this case comes tomorrow and you need something, check out this link. So this covers the whole of performance rights. Any doubts? Because we'll be moving on to different topics. Any doubts, Bourne? Moving on to copyright societies, okay? Copyright societies, even I have not covered it because this was done by a research scholar. It comes under section 33, which talks about how you register a copyright society. So what is a copyright society? We'll just have a small discussion on this. So we're all authors, okay? Let's say we're all very impoverished authors. We're all poor authors. We're all very poor music directors. And in front of a producer like Karan Johar or some big shot mafia, what are we, right? We don't have the political lobbying. We don't have the funds to fight cases. So what do? We all come together and form a society. All the lyricists come together, make a society, a lyricist society. All the sound recorders come and make a sound recording society. All the music composers come and form a music composing society. So because together we have a lobby, right? So this is what a copyright society is. So how do you register a copyright society comes under section 33. And there's some drama in this case where there were two societies that came up, okay? PPL was the first sound recording society and RNPL came up later and they got registered under section 33. Then PPL challenged it. In PPL versus Union of India, they said, how can they also register as a society? We are the first society. So this was the case that happened. And what do these societies do? They determine royalties that have to be paid. They all come together like a trade union, okay? So when a song is released, the producer can't blackmail me, arm twist me, and then force me to take less royalty. The society will come and stand for me and they will determine the royalty. So this is the reason that societies exist. And there's a PPT that has been shared. We'll go over it at the end if you have time, okay? Regarding copyright societies. Don't break your head. I don't think this is even coming tomorrow. Coming to the next topic and the most important topic, the final topic pretty much today and the largest, copyright infringement. So what have we studied till now? From the start, from the first test. What is copyright? What is the jurisprudence behind copyright? Then we studied about all the kinds of licenses that exist. Then we saw about orphan work today. After orphan work, we saw performance rights. All these talk about rights, right? Now we're going to talk about copyright infringement. What happens when you break these rights and how can you break these rights? So an author of any work, he has copyright under section 14. Section 14 lists all the rights that a literary work has, a musical work has, a dramatic work has, a computer program has, a sound recording, cinematographic work, an artistic work, all these rights. And any infringement of copyright, trademark or patents have absolute and strict liability. What does absolute liability mean? There's a case called Rylance versus Fletcher that we studied in tort law. So in that, what happened was, one person was constructing a reservoir, okay, on a hillside, as in he wanted to dig and build an artificial lake. But when they were digging, when the contractors were digging, they found that there was some improperly filled mine shafts that were leading down, that was connected to some nearby mine that was running, okay, Ryland's mine. So what they did was they did not worry about it. They just filled some concrete over it and they built the reservoir. And once the reservoir was built, the water leaked through the shafts and then destroyed the entire mine. So Rylands took Fletcher to court. And even though Fletcher said that he had no fault, he did not intend to do it. He did not intend for the mine to get destroyed due to the dangerous nature of the substance involved. As in the whole situation was so dangerous, right? Innocency is not an excuse. You being innocent, whether you planned it or not, the liability is absolute. This is called absolute liability. And there's one more example, sir, gave. So Sharath has a cat and the cat scratches Anil. Sharath tries to stop the cat. Okay? He takes all his due diligence. He tries to defend Anil. He tries to keep the cat away, but the cat still manages to scratch him. Sharath is free of liability. Okay, because he put his due diligence, right? But in case Sharath has a tiger, he brings the tiger knowing that tiger is a dangerous animal and he keeps it next to Anil. Now the tiger scratches Anil. And even though Sharath tries to stop the tiger, somehow he tries to poke the tiger something, it still scratches Anil, right? Due to the dangerous nature of the situation, the liability is absolute. Because Sharath willingly created the situation, such a dangerous situation, the liability is absolute. This is called strict and absolute liability. And why are we talking about this? Copyright infringement. Whether you intended to infringe the copyright or not, it is always absolute and strictly liable. Let's say I play some Bollywood song in some concert, okay? Like, let's say there was a fest that happened in IIT Kharagpur. I played some famous movie song there. And it's copyright infringement, right? Because I'm playing it to a large audience. But I say that I did not intend to infringe copyright. I just played it innocently. I did not know there was a law also. Even if I claim innocence, since copyright infringement has absolute and strict liability, I will be held liable. Okay? Infringement of copyright is an absolute liability. When you violate the terms of a license, there is copyright infringement. There must be strict compliance. And there are two violations that happen. Let's say I've licensed my song to some film producer, right? In case there's a violation, there'll be a contractual violation. As per the agreement, he has violated it. In addition to that, there's a violation of copyright as well. And even though whether you intend it, you don't intend it, all that nonsense, there is always strict absolute liability. So, perfect. Any doubts? That's all. So the point I was trying to make here is, when you infringe copyright, whether you're innocent or not, liability will exist. So you can't claim innocence. If there is innocence, damages may be relaxed depending on the court. If they really feel that you're really that innocent, damages may be reduced, but damages are there, okay, because the liability is absolute. Moving on to the next concept. What are the different types of infringement? You learned what is infringement, right? Where you violate some person's copyright. Now, and then you saw what are the kind of punishment that you get when you violate infringement, right? Because it is absolute liability. Next, you're going to see the types of infringement: primary, secondary, and tertiary infringement of copyright. You're not going to see tertiary, you're only going to see primary and secondary. Very simple, like basic. What do you understand from primary infringement? I go and I infringe copyright, right? I take a book, I copy it. I take Anil's book, I copy it and I sell it. That is primary infringement. Now I take a book, I take it to Bhuvan's Xerox shop, I Xerox the book, I make 1,000 copies at Bhuvan's shop, and then I sell the book. I'm the primary infringer, right? Bhuvan has helped me, has assisted me. So Bhuvan is the secondary infringer. Are you getting an idea of how the concept flows from here? So starting off, primary infringement, okay? In a compulsory license, the registered, blah, blah, blah. So how do you do copyright infringement under the primary thing? When you do all the things mentioned in section 14, all the rights of the author, if you violate it without the permission of the author, it is copyright infringement. When you go beyond the terms of a license, that means that is copyright infringement. When you go beyond the terms of compulsory license that we studied under section 31A, section 31D, that is also primary infringement. Don't break your head too much. It just tells you what all is infringement. Basically, when you copyright, when you steal somebody's work directly, when you're directly infringing copyright, it's called primary infringement. Okay, so under the American authority, in the American copyright law, it comes under section 504. British authority comes under section 16.2. And Indian authority, section 51, talks about copyright infringement. So let's see what does section 51 say. So where any person, he does anything, does anything to violate the exclusive right that has been conferred upon the author. This is what copyright infringement is. Basic understanding of copyright infringement. There's more to the section, but we'll see it under secondary. Okay, it defines secondary infringement in the next part of the section. But what I'm trying to convey is, summarizing all of this is, primary infringement is where you directly infringe the copyright. Where I directly take a work, copy it. Okay, or if there's a direct license that's there, I directly break the license, I'm the primary infringer. If there's a compulsory license, if I directly break the compulsory license, I'm a primary infringer. Okay, that's all. Don't break your head. I know I'm trying to butcher this. It's a little abstract. Okay. So next concept before we move to secondary infringement is, how are you going to prove copyright infringement? Okay, I'm the author. Somebody has infringed my right. How will I prove it? Whether the infringement has happened or not, it's a question of fact. It'll have to be proved, right? How will I prove the fact? Under Indian Evidence Act, I'll have to supply some kind of evidence. So the plaintiff must prove the copying in fact, and it has to be proper proof. And what are the two types of proof I can give? I can either give direct evidence or I can give indirect evidence. And what is direct evidence? Direct evidence is bullshit. Nobody can give it. You have to give like proper CCTV footage of me going to Anil's computer, copying the whole novel with the audio recording of me telling someone that I'm copying Anil's novel. It's not going to happen, okay? Nobody has direct evidence. Indirect evidence, there have to be two things. There has to be a substantial similarity between my work and the author's work. And I must have some form of access to the copyrighted material before doing the work. Okay, because there's something called independent creation, right? Independent creation theory says that if two people make the same work out of coincidence, somehow both of the works are exactly the same. Still, both of us get copyright if you can prove that it was done independently. So there has to be, you have to show not just substantial similarity, you have to show that the other person, the person who has made the other similar work, had some kind of access to the copyrighted work. And how do you determine both of them? So for substantial similarity, what are the two things that have to be proved? Comprehensive non-literal copying that we studied before, or fragmented literal copying. Comprehensive non-literal copying is where I take Harry Potter, the whole story, I just change the names and I rewrite the whole story. So I've comprehensively copied all the non-literal elements of the story. Or fragmented literal elements of the story. As in I take Harry Potter, I don't change anything, but I copy the first chapter, the fifth chapter, the 10th chapter, every 5 chapters I'm copying. So that is fragmented literal copying. So if either of this is done, it's called substantial similarity. Second one, the access to the copyrighted work. So it has to be something substantial. Let's say Sharath releases a book, which is not very famous. It's moderately circulated. Anil has written a similar book, very similar book. And you find out that Anil has come to India. He has flown to India and he switches a flight to Singapore. So he has stayed in India for 2 hours. And Sharath shows that there was a bookstore in the airport that had this specific book, had Sharath's book that day. Can you say that this was substantial access? Can you say that Anil had solid substantial access to the work? You can't, because it's a very low degree of access, correct? But if you can show, if Sharath can show that Anil has stayed in India for a few days, he has gone to a certain bookstore which actually had Sharath's book, then the access is slightly more comprehensive. Again, it's still vague. It's little more comprehensive. You have a chance to build a case. Okay. So how do you determine the degree of access? Can you say that only 10% access existed, or that person had 90% access? Because even at 90% access, it may still be a coincidence. Like I might literally have the book next to me and I might have not even read it. It might still be coincidence that I match the book, right? So the general understanding is if the chance of access is low, then the chance of coincidence is high. They're inversely proportional. As in, if I've not had access to that book and I've still managed to copy it, then it was complete coincidence, right? The chance of coincidence is very high. And the opposite is also true. When the chance of access is high, as in I've had a lot of access to the book, then the chance of coincidence is low because it's inversely proportional, because there's lesser chance of it being coincidence. So it is completely down to the subjective discretion of the judge and the court. And whatever the court decides is what you have to follow. And what is the British standard? The British law also says the same thing. There has to be substantive, objective similarity between the two works, and there must be some form of casual connection between the two works. Again, you have to show some form of access. This is the second concept. Have you guys understood? Because we're moving to something else after this. Is this clear? How to prove copyright infringement. So I'll just summarize what all we covered from the start so that you guys get an idea. So the first thing we covered was, man, there's a lot, man. There's still a lot more left. First one is orphan work. What is an orphan work? Where the author has not been traced. And if there's an orphan work, how do you still go ahead publishing the work, right? Second one that we covered is, second concept is performer's rights. An actor to a film, what all rights does he have? Performer's license, the moral rights of a performer, all these we discussed. Moving on. After moral rights of the performer, we reached copyright societies. Why do you need copyright societies? Why do they exist? What are they? Moving on. Copyright infringement. What is infringement? What kind of liability copyright infringement has? Strict, absolute liability. Moving on. We covered what are the 3 types of infringement of copyright: primary, secondary, tertiary. We're going to see only primary and secondary. Primary as in where the direct infringement happens. Secondary as in where you're abetting the infringement. That is called secondary infringement. Okay. Then after that, we come to how do you prove copyright infringement? One, direct evidence. Second one, indirect evidence. Direct evidence is bullshit. Nobody can prove it. You'll have to get actual CCTV footage, which no one's going to get. Indirect evidence, you need to have 2 things: substantial similarity of the works, comprehensive non-literal or fragmented literal. And second one, access to the copyrighted work. It has to be something substantial. Okay. And if it's a very low degree of access, good luck. You'll have to prove to the court. If the access is more comprehensive, you have a chance of winning the case in court. Okay. Moving on. Theory of subconscious copying. We'll finish this and I need a break after this. So there's a case. Okay. If you understand the case, you'll understand what is subconscious copying. Three Boys Music Corp versus Bolton. And this is the YouTube video for the case. Check out the video. It's actually pretty nice. So Michael Bolton was a famous singer in the 90s. Remember the dates, okay? Michael Bolton is a famous pop star in the 90s. And Isley Brothers, they were a band in the 60s. There were three guys and they recorded a song. And it was not very popular. Okay, it did not reach the top 100 chart, but it was reasonably good. And Michael Bolton, 30 years later, in the 90s, he makes a very similar song. And Three Boys Musical Corporation, as in they filed a case. The Isley Brothers filed a case claiming that it was copyright infringement. Now, what happened in this case? Michael Bolton, he was a child, right, when the song released. And he grew up in an area where the radio jockey of that area, these Three Boys Musical Corporation, they produced the RJ from that area. The RJ said that he has played that song multiple times during the childhood of Michael Bolton. So Michael Bolton has heard that song multiple times. Okay, what do you think of this? Is this a low degree of access or high degree of access? It's a very low degree of access, right? How are you going to prove this? Even if the RJ is played, how are you going to prove that Michael Bolton listened to that radio show, that he listened to the song at that time? So it's a very low degree of access, right? Now see how Michael Bolton got screwed in this case. So Michael Bolton, what he did, very oversmart guy. He comes, in order to support his own case, he deposits a working tape. And what is a working tape? When the recording of the song happens, there's one camera that records all the working, that's all the entire event that's going on, all the discussions that happen, all the changes to the song that happen. This is like to maintain minutes of the meeting, right? Just to maintain a record of the whole event, just to get an idea of revisiting some part of the song, all that. So one camera that was recording everything that was going on during the whole recording of the song, that was submitted as evidence by Michael Bolton. And listen to this. In this recording, in that working tape, it was heard that Michael Bolton saying, he was telling one of the music directors, he said that, I've heard this song from somewhere, but he says that I think it's similar to some other song. But he does not say Isley Brothers, okay? He says, I think it's similar to these guys' song. And he submits a recording of this to the court. He says that, look, I know that it sounds similar and all that, but I'll give you proof that even though it is similar and I might have heard it in my childhood, I thought that it was some other song, not the Isley Brothers song. And he submits this as his defense to the court. Now, what is your first understanding? Copyright infringement is strict and absolute liability. Whether you intended to copy these guys or whether you innocently copied them, it does not matter. It's absolute liability, right? So what did the court say? Court said that he has heard the song and the memory has played a trick on him and he unconsciously used the song. Therefore, copyright infringement is absolute and he had infringed it. And the court quoted Judge Learned Hand, the famous judge that we always hear. Everything registers somewhere in our memories. If I go fall down in my cycle, it's somewhere in my memory. Every day I see a cycle later on, some bad thought will come to me, right? Because it's subconsciously there in my head all the time. And no one can tell what may evoke it. Once it appears that another has in fact used the copyright as a source of his production, he has invaded the author's rights. It is no excuse that in doing so his memory has played him a trick. So just because Michael Bolton said that, in his mind, he did not know he had copied Isley Brothers' song. He thought it was somebody else's song. That is no excuse. Because copyright infringement is strict and absolute. Even though it was bare access, him listening to the song on the radio, it was very bare access. You can't prove it in court. And the song was released in the 60s, 30 years back. And the RJ played it during his childhood. You can't prove it in court, right? So if Michael Bolton had just shut his mouth, if he had not submitted any proof, he would have won this case. It alone was not enough proof, but Michael Bolton submitting the working tape confession was the final nail in his coffin. Therefore, him submitting the defense screwed him over. So if he had just shut his mouth, he would have won the case. Him being oversmart is what lost him the case. Okay? Is this case clear? Do you have a very vivid picture of this whole case? Moving on to George Harrison's case. Okay? Very small, nothing much in this. Apco Music was Harry Song's music. George Harrison is a Beatle, okay? One of the famous band Beatles. And he performed a song on stage. And basically Apco Music came and said, no, this is our song. You have infringed our copyright. So what happened in this song? It was held that it was subconsciously copied. And they went to court and the court also said that, yes, it was a subconsciously copied song. So why I listed this case is, tomorrow if subconscious copying comes, list the Michael Bolton case and list the George Harrison case. Okay, because both talk about subconscious copying. Moving on to the next concept. Have you guys understood subconscious copying? Any doubts? No doubts. I need a 5-minute break. Okay. Where is the meat, man? Yes, I'm back. Get back, all of you. I'll give you 1 more minute. 60 seconds. I really think we need to have breaks in class also like this. Like 5 minutes break just to stand up, reset. What do you think?
Vishnu, can you summarize what is covered in the primary infringement? Just like comprehensive literal copying and non-literal copying.
Fragmented literal and comprehensive non-literal. Okay. What it means is, I think the PPT had it from the first test. So what it means is, let's say there's Harry Potter, okay, and I take the book and I don't copy the whole story. I copy the climax, I copy the starting and some event in the middle. What is it? It's fragmented copying, right? It's fragmented literal copying. Literally, I've taken the words and I put them in. That is copyright infringement. Second one is comprehensive non-literal copying. Okay. And what is non-literal copying? I take the same story, Harry Potter, I change all the names. Harry Potter becomes Hari Krishna, Voldemort becomes Vishnu, and I make the story. And now I can go to court and I say, look, I've not copied the work. I've changed all the names. But this comes under non-literal copying. Okay. Non-literal copying has to be comprehensive. As in, I take the whole story, I only change the names and I publish it fully. So for the infringement to happen, it should be comprehensive non-literal. As in, the whole story has to be non-literally copied, because fragmented non-literal copying does not come under copyright infringement. I've put a table in the PPT with whether it comes under copyright infringement or not. Where is the PPT, man? My screen is still shared, na? Can you see my screen?
Yes.
Yeah. Yes. So where is that table? Yeah. So basically Harry Potter is there. I change his name to Harish Salve. Hogwarts becomes Hawa Mahal. Voldemort becomes Mangal Singh. Right? The expression is not copied. Only the structure is copied. Only the story. So this is a non-literal expression. And plaintiff has to establish that the defendant has comprehensively copied the structure of the work. And look at this now. If it's comprehensive literal copying, yeah, it is obviously where I take the whole story, I literally copy it. If it's fragmented literal, that is also infringement. Where I take the first half, second half, and the climax, that is also infringement. Comprehensive non-literal copying, yes, that is also copyright infringement. And fragmented non-literal, this is not infringement. Where I change all the names, Harish Salve, Hawa Mahal, and I take only bits and pieces of the story, then there is no similarity, it is not copyright infringement. Okay, so for me to establish primary infringement of copyright, it has to be the first three, either comprehensive literal, fragmented literal, or comprehensive non-literal. Okay, coming back to, where were we? Yeah, coming to section 61. Okay, this is something that we covered at the very end. Let's do it over here only. So if you file a case, copyright infringement case, how do you proceed in court? Practically, how do you proceed? That's what section 61 talks about. Copyright, there are two types of rights, right? Right in rem, right in personam. Right in personam is a contract where you have a specific set of rights against some person. And right in rem is rights against the entire world, tort law, criminal law. So what is copyright? Copyright is a right in rem. It is enforceable against the entire world. I don't need to make a specific contract with someone for me to enforce the right against them. So what all do you need to prove? Okay, I'm a aggrieved party. Somebody has infringed my work. I need to prove two things. First one, who owns the copyright? I have to prove that I am the copyright owner first. Right? I can't go and fight Bhuvan's case if he owns the copyright. I have to prove I am the copyright owner. Second, I have to prove the copying has occurred in fact. I have to give direct or indirect evidence. It's all a recap. Just remember what I taught you. Direct evidence, if I can find it, well and good. But I don't have direct evidence. So indirect evidence. So what are indirect evidence? There has to be substantial similarity. Right? And substantial similarity, both comprehensive, non-literal, fragmented literal. Shriari didn't even need to ask. We are revising everything again. And what is access? They should have some form of access to the work. It can't be low degree of access. It has to be something substantial and solid. But even then, it depends on the court. It's the court's discretion. Second one, plaintiff's work is called as the allegedly infringed work. As in, I'm the plaintiff, right? Somebody has infringed my work. So my work is called the allegedly infringed work. And the defendant's work, the one who has copied, his is called the allegedly infringing work. Second one, next what does the court do? The court has to apply the abstraction filtration comparison test or the abstractions test. Abstraction filtration, AFC test is applied for computer programs. Abstractions test is applied for literary works to extract the copyrightable nectar. As in, once they do the filter, you'll get exactly what is copyrighted material. And once they've got the golden nectar, if there is some substantial match with what they've extracted, then it is copyright infringement. And what is the next concept? Copyright infringement is strict liability, and therefore the act occurring itself will be culpable. What is the thing called? Res ipsa loquitur in torts we studied, where just the accident happening, where just the act occurring is enough to have culpability. Moving on, who can judge this? Let's say I take it to some court and the judge has no idea about music and he's in property law, he's a civil expert, right? Judges. So generalist judge cannot do the evaluation. A specialist judge is needed. Right? Even if the why do you need a specialist judge? Because the judge has to understand, right, the nuances of music. Let's say I take a computer program. I say that Anirban has copied my computer program to the judge. Now the judge has not even studied about computers. How is he going to do this AFC test and understand it, right? So a specialist judge, a judge specializing in computer programs, he has to come to decide the case. And the infringer loses the case. Let's say I filed a case against Anirban. Anirban has lost the case. He may appeal to the court saying that it comes under fair dealing doctrine. Today, the final concept we'll be reading is the fair dealing doctrine. Don't worry about it. We'll cover it later. He may make an appeal on this. So what are the comparison tests they use in courts? There are two tests, okay? Extrinsic, intrinsic test. Second one is melodic reduction test. We won't be seeing the second one. We're only getting an idea of what is extrinsic, intrinsic test. So Sharath has written the lyrics of a song, okay? He's written lyrics. So he has the lyrics copyright. Then he has composed the music for it also. So he's the music copyright holder. Now Jishnu comes and he makes a similar song. And a reasonable common man, as in some normal individual, he's not able to tell the difference. For him, he feels the songs are the same. They sound very similar. So if a reasonable common man is able to find the sound similar, then you can go to court, right? You can say that the song has been copied. But Jishnu is saying, I've not copied the song. I refuse to acknowledge any form of copying. And the similarity comes due to various things, right? The rhythm of the song, the tempo of the song, what rag it follows, all that. So the court, now what does it do? It sends the song to a specialist, the music specialist, to determine the similarity. If a person with no knowledge of the music gives a verdict, it will be an injustice, right? So a generalist judge cannot give the verdict. An extraneous expert, as in some musical expert, has to decide the degree of similarity. And he has to establish sound, logical, and cogent parameters to show the similarity. Okay, so what I'll just summarize what all we covered. So how will you take the case to court? First, you have to supply evidence, right? Direct or indirect evidence. Second one, there has to be a comparison test that has to happen, and a generalist judge cannot do it. You need a specialist judge. What are the two types of comparison tests? Extrinsic, intrinsic test, melodic reduction analysis. So once the case goes to court, the court will send the song to a specialist to determine the similarity. Okay, very simple. And both sides can bring their own experts, so that you have a fair chance to fight the case, right? And is it a civil suit? Yeah, it is a civil suit, right? So it's filed under Section 9 of CPC, and all the proper plaintiffs have to be included in the suit. Perfect. Nothing else. So okay, this part is a little complicated. Let's go a little slowly. So you understood, right, the whole procedure. It's very abstract and unstructured. I'll go very slowly now. So who are the proper plaintiffs who have to be included in the suit? You've learned this, right, in CPC. When you file a case against someone, all the plaintiffs have to be included. All the defendants have to be included. All the proper parties, necessary parties have to be in the case. So whom should you include in a copyright suit? Okay, only the owner of a copyright can file the suit, right? Only the author or the owner can file the copyright suit. But who else can be treated as an owner? This is the example, okay? Krishna is an author. Krishna has written a book. He's the author. He licenses it to Ruchika. He gives her an exclusive license. He's taken 5 crores. He takes 5 crores from Ruchika, gives her the exclusive license for 60 years. Now there's a copyright infringement, okay? And now Krishna tells Ruchika, look, I don't want to go to court. I've got my 5 crores. I'm happy. Okay, but somebody's infringing the copyright. So what can Ruchika do now? She has no other option, right? Now, because Krishna is least bothered of his rights, he's in Maldives enjoying his vacation. Ruchika has the right to enforce the copyright infringement in this case. Why? Under Section 54, an exclusive licensee is also considered as the owner of the copyright. Section 54 states this. Okay, so only the owner can file a copyright suit, right? So under Section 54, even the exclusive licensee can file the suit. Now, under Section 61, it says that in every civil suit or other proceeding regarding the infringement of copyright instituted by an exclusive licensee, basically this whole case where Ruchika is filing the case, the owner of the copyright shall be made a defendant. Listen to this. The owner of the copyright should be made as a defendant to the case. And where such owner is made a defendant, he shall have the right to dispute the claim of the exclusive licensee, blah, blah, blah. So when Ruchika files a case against the infringer, let's say Krishna has written the work, Ruchika is the exclusive licensee, Anirban has infringed the work. Okay, Ruchika cannot file the case first, right? Because the owner has to come. But Krishna refuses to file the case. But under Section 54, Ruchika can file the case. So she files a case against Anirban. And she has to include Krishna also as a defendant. The exclusive licensee has to include the owner of the copyright also as a defendant. Unless the court otherwise directs. Unless the court excuses, you'll have to do this. Okay. Exclusive licensee must make the owner a party to the suit. Remember this. This is the most important concept. Moving on. Ruchika will also implead Krishna as the second defendant. And if the court feels he can be removed, no issues. And if he fails to appear, if Krishna, even after being made a second defendant, he fails to appear, an ex parte decree will be put on him and res judicata will apply, all the same things. Okay. Section 54 says that in case there's an anonymous work, you don't know who the owner is, right? Orphaned work. Then who can file the suit? The publisher can take up the suit. That's what section 54 says. Okay. And one more situation is when there are joint owners. Two of us have written a book. Me and Bowen have written a novel. Okay. And one of the owners says, I don't want to file a suit. Bowen says, let's leave it. Let's not file a case. So can I go and file a case? Because both of us are owners, right? I can file a case, but I must include Bowen as a defendant. That's what it's saying. It says that the other author must be impleaded as a pro forma defendant for the conclusive determination of the case. Okay, I'll just summarize the whole section once because I butchered it completely. I can already tell. Section 61 talks about what is the case procedure for copyright infringement. How do you file a case? Copyright is a right in rem. Okay, you need to establish two things: direct evidence, indirect evidence. Direct evidence impossible. Indirect evidence you have to show this to the court. Next, the court will apply the AFC test, the abstractions test, right? And a generalist judge cannot do the evaluation. A specialist has to be brought in. And the court applies these two tests to determine, right? It takes the work, submits it to an expert, and both sides can bring their own experts. Next, copyright suit is a civil suit. It comes under section 9 of CPC. So proper plaintiffs, necessary parties, all the proper parties have to be included. So who are the proper parties? In case the owner refuses to file a case, then the exclusive licensee may do so. After impleading the owner as a defendant, exclusive licensee must make the owner as a secondary defendant. Okay. And then in case it's an anonymous work, orphaned work, then the publisher can file the suit. They have the right. Third one, where there are joint owners, multiple authors, me and Bowen are the authors. And Bowen says, let's not file a suit, let's leave it. In that case also, I still have the right to file a suit. But then I must implead Bowen as a second defendant. I must implead him as a pro forma defendant for the conclusive determination of the case. And in case, even after impleading the owner or the author as a defendant, that person fails to show up, an ex parte decree will still be binding on them. Okay, yeah, Shiri, go on. Oh man.
Why, like, owner should be defendant, he should be plaintiff, right?
That's what section 61 says this. Section 61 says that the owner of the copyright shall, unless the court otherwise directs, be made a defendant. Section says it. I know logically they should be made a plaintiff, but don't you feel they're violating their duty? They have a duty, right?
Yes,
Once they've granted an exclusive license, they have a duty to stop the infringement. But since they've refused to follow their duty, they have to be made a defendant in the suit. That's all. Oh man. Secondary copyright infringement. I need 2 minutes, okay? My cough is getting worse and worse. Yeah. Back. All of you back. You on scale. Beat everyone up. Unmuted, na? Yeah. Let's go. Secondary copyright infringement. So what did you see now? Primary copyright infringement you saw, right? Direct infringing. Next one you're going to see is secondary copyright infringement, where you're not directly doing it, but you're assisting them. In the US, there's no statutory provision. Okay, their Copyright Act does not talk about secondary infringement. Only the case laws discuss it. And in India and UK, the statute exists. Section 51, the second half talks about secondary infringement. So what are the different types of secondary infringement? Contributory infringement, vicarious infringement, and inducement infringement. We're not going to see the last one. Even inducement, we're only going to see it for a short while. Let's say there's a copyright infringed work. Bowen has copied someone's work. He has uploaded it on the internet. Now I go and download that work. Right? I've not directly infringed the right of the copyright. I've indirectly done it. So I've indirectly violated the author's right of infringement. So me, by downloading it, am I also liable as a defendant? Are you getting an idea of what secondary infringement is? Where you're not directly doing it, but you're in some way assisting it or abetting it or contributing to it, right? So secondary infringement, US has case laws, same thing. Under section 51, let's see what the section says. It says that where the person, any person permits for profit any place to be used for the communication of the work. As in, there is a copyright infringed song, okay? Someone has taken a song which is infringed copyright, and I allow them to play it at my theater, or I allow them to play it in my restaurant. So I've permits for the profit any place to be used for the communication of the work. That means I'm a secondary infringer of copyright, right? Are you getting an idea of it? You'll understand it when you see the cases. Coming on. Yeah, so there are three types I told you, right? Contributory infringement. So when a person induces or instigates another person to materially contribute to the copyright infringement, when I'm inducing another person, then such a person is called as he'll be held liable for contributory infringement. What are the conditions? There are two conditions. One, the infringer had the knowledge of such infringement or has reason to know. He might not even know it, but it should be something apparent. He should know that it's being used for infringement. I have a Xerox shop, okay? And somebody is coming to me with a new novel that has been released, and he tells I want to print 5,000 copies of it. Now I might not have the knowledge that he's infringing copyright, but don't you think it's reasonable for me to know that he's doing something wrong, right? Second one, the infringer has induced or encouraged the direct infringer or has materially contributed to the primary infringement, where I'm giving him money, I'm allowing him to use the Xerox shop for free, right? That's called the induced or encouragement, and both of these have to be proved. So I have a Xerox shop, I allow the infringer to photocopy. I am a secondary copyright infringer. Simple now. Why? Because I have knowledge. Even if I don't have knowledge, I have reason to believe, right? Or there has to be some form of substantial participation where I'm allowing him to use the Xerox machine. Both have to be proved. This is the first case. Sony Corp of America versus Universal City Studios. What happens in this case? So Sony released a recorder, a tape recorder called a Betamax recorder. You can record programs on it, okay? TV shows. So one lady, she comes home, she uses the recorder to record a TV show, and the TV show is obviously copyright protected, right? So now the lady is a primary copyright infringer, correct? Because she has directly infringed the copyright. Now Sony, they released the tape recorder, right? Are they a secondary copyright infringer? That is the question. Now I think you would have got an idea of what is primary and what is secondary. So what does the Supreme Court say? It determined that Sony, let's read it out. It's actually very clear the way they've explained it. A manufacturer of video cassette recorders did not infringe on copyrights. And by manufacturing and marketing Betamax VCRs. So the act of them manufacturing recordable tapes, that is not violation of copyright. Okay. Universal, which own copyrights on many blah, 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 blah. Okay. Yeah, the studios, as in both the plaintiffs, they argued that Sony contributed to the copyright infringement. So what did they say? It was secondary copyright infringement and it was contributory infringement. The first one that I said. They said Sony has contributed to it by enabling and encouraging Betamax owners to record the copyright television programs. So what are the two conditions? First one, there needs to be knowledge or reason to believe. Second one, they have to induce or encourage, or they have to materially contribute to it. So both the studios, Universal and Walt Disney, said that Sony has done both of this. So it is contributory infringement of copyright, right? What does the Supreme Court say? In a very close vote, they said that Sony did not infringe on the studio's copyrights by manufacturing and marketing VCRs. And I'll just tell you what it said. Yeah. There must be a balance between the copyright holder's legitimate demand for effective. Nothing seems perfect. If the case comes tomorrow, just copy paste this, okay? I'll just give you a summary of what happened, what the court said. So there's something called the staple article of commerce doctrine, okay? And what does this state? It says that when there's a certain product, like a tape recorder, and it's a staple article of commerce, as in something that's being sold for a substantial non-infringing use. What does this mean? Let's say there's a water bottle, okay? What is the use of a water bottle? To drink water from. But if I use a water bottle to go hit someone, can I start banning water bottles? You cannot do that. Why? Because the substantial non-infringing use of the water bottle is drinking water. And I'm using it for some other purpose, as in hitting someone. Use the example, okay? So what the court said was, applying the staple art of commerce doctrine, it says that the VCR was not made for the purpose of copyright infringement. It had a substantial non-infringing use. Okay, that is distributing material to people. And because it had a substantial non-infringing use, Sony is not violating copyright. And they applied section 271 of the US patent law, which says that whoever offers to sell or sells something made or especially adapted for use in an infringement of such patent, which is not a staple article or commodity of commerce suitable for substantial non-infringing use. So it says that basically the summary is, can water bottle users stop selling water bottles since they can be used as weapons? No, because they're dual use articles. What are water bottles used for? For storing water. And what are Sony's Betamax recorders used for? For recording videos, not for copyright infringement. And what do the codes say? I'll just quickly summarize it. What do the codes say? Yes, Sony did enable the infringement to happen. It did somewhat did enable the person to do it. But what was the purpose of Sony Betamax recorders? It was a commodity of commerce, but it had a substantial non-infringing use. Okay, therefore it does not come under contributory infringement. This is what the codes say. Okay. Just remember this concept, staple article of commerce doctrine. So if a product has substantial non-infringing use, then it does not come under copyright infringement. Next, we come to the next concept, vicarious infringement. Contributory infringement is where the person assists the person, right? In vicarious infringement, where a person or entity gets benefited because of the infringement done by the primary infringer. Where does this happen? Suppose I run a movie theater or a drama theater and some drama is going on. Some copyright infringed drama is running there. I'm getting benefit, right? I'm collecting rent. I'm selling tickets. So where the person or entity gets benefited because of the copyright infringement done by the primary infringer, where I'm not directly contributed, but I'm getting benefited. So such a person will be held for vicarious infringement. So what are the two conditions for vicarious infringement? Where you have a right and ability to control the infringement, where I can stop the performance from happening. Second one, where there's a direct financial interest in the infringement, as in where I'm making some profit out of it, right? Some money out of it. So two questions that have to be asked. Whether the alleged secondary infringer has the right and ability to control the activity, perfect. Whether he has made a substantial gain out of it, some kind of profit has to be tied to it. And knowledge does not matter here. Knowledge or lack of it does not matter. It's strict liability, like we have discussed. Wait, okay. So we will discuss a case under vicarious infringement. Is this clear? Any doubts here? For contributory and vicarious infringement. I'll move on, wait. Just remember the two conditions. If it's contributory, there are two conditions. If it's vicarious, this thing, there are two conditions. And for the contributory negligence, contributory infringement, there's a case, Sony Betamax case. Okay, and in that case, even though Sony was contributing, court held that it was not infringement because of the doctrine, staple article of commerce doctrine, because the VCRs had substantial non-infringing use. Moving on. Yeah, so this is the chart Sir showed in class. So in copyright infringement, you have direct or primary infringement, or you have secondary infringement. Primary infringement is obvious, directly you infringe. Secondary infringement, you have two types, right? Contributory infringement, vicarious infringement. Inducement, we'll see it at the very end. Under contributory infringement, you have two types, right? Two conditions. Knowledge, you need to have knowledge or reason to believe. Second one, there needs to be some form of substantial participation. Under vicarious infringement liability, you need to have two conditions. One, where you have the right and ability to control the infringement from happening. Second one, some kind of profit that you're making from the infringement. Okay. Now, when we discuss this jurisprudence, as in what is the philosophy between these two concepts, you'll understand the concepts properly. So, why does secondary copyright infringement even exist in the first place? You'll be like, okay, one person is violating the copyright. You book him. Why do you want to bring in the secondary players, the people who are assisting him, all that? The concept is, if there is no secondary infringer, if there is no one with a Xerox shop, how will the primary infringer exist in the first place? Simple concept, nah? If I don't own a movie theater where the copyright performance is played, infringed performance is played, then the primary infringer won't exist, right? So the concept is, if there is no secondary contributory infringer, then the primary guy won't exist. So it is cheaper in the long run to stop the secondary infringer. This is the reason why secondary copyright infringement exists. Okay. So if I stop the secondary infringer, no more primary infringer can exist. That is the jurisprudence. So in the Sony Betamax case, what did the court say? The court held that the users of the cassette was fair use. And if Sony is stopped, let's say Sony is stopped now, like the whole company is shut down. The copyright infringement will be stopped since no more recorders are sold. Perfect, no? So the focus shifts from the primary to the secondary infringer. What I'm trying to get at is, if Sony had stopped making the recording tapes, will anybody be able to record tapes? Nobody, right? So the primary infringer is also stopped. So this is the main policy backdrop between why you have secondary infringement liability. Okay, moving on. There was this was established in a case also, Gershwin Publishing Corp versus this thing, where the court held that without a primary infringement, there can be no secondary infringement. So what are the ingredients that need to exist for a secondary infringement? First one, there needs to be an infringement itself. Perfect. There needs to be some form of prior knowledge where the person actively knows or he constructively knows, right? Where you directly know that infringement is going to happen, or you passively know, as in where you have reason to believe that it's going to happen. And there needs to be some form of substantial participation or material contribution. All this that we studied, right, under contributory secondary infringement. Moving on, Anil has a photocopy shop, and someone wishes to come with Amish Tripathi's book and they want to get it photocopied. Now, don't you think, even though Anil might not directly know that it's a copyright infringement, don't you think he has reason to believe? He should have, right? So is there participation from Anil? Yes, because he's providing facilities. Does he have knowledge? Maybe no, maybe no. So it's not actual knowledge, but is there constructive knowledge? And is he being willfully blind? Yes, right? So what is actual knowledge in this case? So if the publisher or the author, they find out that Anil is photocopying these books, they send a legal notice to Anil to stop this, that he's infringing copyright, and Anil continues to make copies, then this would be actual knowledge and he will be held liable. Just a small example. Now coming back to the Sony Betamax case. When you use a tape recorder to record a serial, right? It's a concept called time shifting, because you're only shifting the time of watching. You were supposed to watch it at 6 o'clock. You record it, watch it at 10 o'clock. So it's called time shifting. Is this fair use? Does this come under the fair dealing doctrine? Yes. Time shifting a program constitutes fair use. And what the court said is, with respect to the secondary liability, the recording was illegal. Her recording it was illegal, but there was substantial non-infringing use. As in, the tape recorders are an article of commerce and they're used for so many things apart from just infringing copyright. So the jurisprudence here is, how do you strike a balance? How do you strike a balance between the interest of the copyright holder and the interest of technology? So this is the dichotomy that happens, law versus technology, as in the law as in the copyright law and technology as in the progress of technology. So in this case, you had Sony that was fighting against Universal Pictures, right? Sony representing technology as in them creating these tape recorders, and Universal Pictures representing the copyright law, the copyright holders, the rights holders. So what did the court say? The court held that it was a staple art of commerce. I'm repeating everything. Let it hammer into your head. What did the court say in this case? It was a staple art of commerce and the VCR had substantial non-infringing use. Therefore, it cannot be held under secondary or contributory or vicarious liability. Although it is widely used for copyright infringement, although many people are using it to infringe copyright, it will not hold. Okay, and look at what the court said. It said that contributory liability could be applied, but the court does not want to stop the advancement of technology. Okay, so the court is saying, yes, you could make a case for contributory liability, but if you do that, technology will be killed. It will send a ripple effect throughout technology. It kills investment and progress in technology. So a balance has to be struck, right? So to not disincentivize companies from creating technological advances. That's it. Let's not even get into this nonsense. Is this clear? Okay, because we keep revisiting the Sony Betamax case. I think you have an idea of what the whole case is about, right? So in this, just a quick summary of all the topics. We saw what was secondary copyright infringement, right? There are two types. One is contributory. Second one is vicarious. Third one, inducement. We'll just see a small part of it. Contributory, you need to prove two things: knowledge or reason to believe, and some form of substantial participation. Sony Betamax case, right? Second one, vicarious infringement, where you have two conditions: right and ability to control. Suppose I'm the movie theater owner. I'll have the ability to control, right? Second one, direct and financial benefit, where I'm deriving profit from it. Simple. Yeah. So we saw the jurisprudence of contributory liability. Now we'll see the jurisprudence of vicarious liability. So what is vicarious? Where did we study vicarious liability, man? In torts, right? What is the concept behind that thing? Master-servant relationship, right? Where somebody is responsible for someone else. So Ajmal has a big bazaar, a very big shop. Sharath has a stall over there in the big bazaar, and he wants to sell music CDs. And they both have an agreement. Sharath pays some rent to Ajmal. Sharath pays rent to Ajmal to conduct business, and Ajmal collects rent and 15% of the profit earned from Sharath. So Sharath has started selling pirated CDs. So he's committing primary infringement of copyright, right? Now, does Ajmal get secondary liability now? Will Ajmal be held for secondary copyright infringement liability? Because now the question you have to ask is, does Ajmal have the right to control what Sharath sells? And has Ajmal made a profit? Because these are the two conditions, right? Whether the alleged secondary infringer has the right and ability to control the activity, and whether he has made a substantial gain out of it. What is the answer here? Can Ajmal peep in and see and control what Sharath does? And what is the concept behind vicarious liability? Respondent superior. Master takes responsibility for the servant. Who's the master here? Ajmal, right? So should he take responsibility for Sharath's actions? And the answer is, it's not very clear. Because how do you define having right and ability to control? You can't really define it, right? It's something very ambiguous and vague. So there was a case that came up. I don't know the name of the case. And in that, the court laid down the principles. Knowledge is not necessary. If you make a profit, it's enough. And there needs to be a right and ability to control. It just laid down the parameters. And there are two concepts that have come up. Okay. First one is dance hall owner liability, and second was landlord-tenant situations. So whenever a vicarious liability case comes, it either falls into dance hall owner liability or landlord-tenant situation. And let me explain both of them. Dance hall owner liability means, let's say there's a dance hall and there's an infringing performance that is happening. Some copyrighted infringing performance is going on there. And the landlord is getting a rent, as in they're paying him rent, and he gets a percentage of the tickets. Every ticket sold, he gets 20% of it. There is direct liability. He will be held liable. But in a landlord-tenant situation, where there's a fixed rent, I paid him rent and I'm staying in his house, right? And the landlord is not earning anything more. Then the landlord is not supposed to peep in and see what the tenant does. So there is no liability. So whenever there's vicarious infringement, there are two situations. Either it will fall in the dance hall owner liability or it will fall under the landlord-tenant situation. If it is landlord-tenant situation, there is no liability. In the dance hall owner liability, there is liability, right? There is strict and absolute liability. So there's a case law. When you see the case law, you'll understand both the concepts. So there was a restaurant run by a father and a son, and the father, he himself came to court and he said that, yes, I decide who performs on stage. I invite them and I have direct control of the performances that are occurring. But he said that, the father said that, I don't take any percentage from the performance. I only take the fixed amount that was fixed. So the father said that it comes under landlord-tenant situation. Okay, so he should not be held liable. Because in the restaurant, a copyright infringed performance happened. Okay, he said, it comes under landlord-tenant situation. I will not be held liable. But what did the court say? He said that the performance happened and the performance attracted more people there. Okay, so he was earning something substantial. Because what does it say here? Whether he has made a substantial gain out of it, right? So the father himself agreed that he has the right and ability to control it. And the performance gathering such a large crowd ended up making him a substantial gain. So the court said that, where did it go, man? Yeah, so the court said that, yes, it was vicarious liability and he has direct liability. And dance hall vicarious liability applies. It's not landlord tenant over here. Second case is even more clear. It's even better. Phonovisa versus Cherry auction. There was an auction that was happening. And there were many stalls, right, in an auction. So one of the stalls, a music stall, was selling copyright infringing music belonging to Phonovisa. So Phonovisa filed a case. They said that they filed a case against the auction itself. They said, look, they have been selling pirated CDs in this stall. So take them to task. They went to the court. But what did Cherry Auction say? They said that we took a fixed rent from the stall owners. We did not collect any percentage of their sales. So they argued that it was a landlord-tenant situation because we took a fixed rent and we cannot be held liable. What did the court say? Phonovisa said that the CDs attracted more customers that explicitly came there only to buy those CDs at lower prices. Second one, there was a very high parking fee that was collected by Cherry Auction. So what did the court say? The court found a cogent connection between the copyright infringement and the profitability. And since they had the right and ability to control what is happening, and since they made a substantial gain out of the whole arrangement, they were held liable under vicarious liability doctrine. And what was applied here? They said it was not a landlord-tenant situation. It was in fact a dance hall owner liability. So there was direct liability. Okay, moving on. Again, it is determined case to case based on facts, because how are you going to prove right and ability to control? Unless like this retard, that father who himself came and said he had the right and ability to control, you can't determine it, right? And to determine whether it is landlord tenant or dance hall, again, it depends on the facts of the case. Or if there is some cogent connection between the infringement activity and the profit that happens, right? That's what the court has said. This is the concept, man. Is this clear? It's a very abstract, unstructured concept. Is this clear to everyone? Because the way Sir did this also, he explained this concept over multiple classes. 10 minutes he'll explain, go away, then again he'll revisit it. So I've tried to piece it all together. Is this clear? Have you guys understood this? Moving on. This thing is not coming, okay? I'll just quickly explain what P2P is. It's not at all going to come. P2P sharing model is, there's a computer. Pierce owns a supercomputer with 100 media files on it, 100 movies. And another computer, there are more computers, right, around this, and they're all connected to this computer, and they can all access the files from this computer. They can all download the files from this computer, right? So do you not see copyright infringement happening? I have my laptop, I have my presentation here. Bhuvan has his laptop and he connects to my laptop, he accesses the file, he edits it and he downloads it. Can I stop him? What happened back in the day, internet was very slow, right? People used to have dial-up connections, and the copyright owners were not scared at all, because they knew that to make even a small download, it will take multiple days to happen. So copyright owner said, fine, you guys go do it. Then Mr. Sean Fanning came up, right? He's the founder of Napster, and Napster is a website where you could download songs for free. So this guy came, he wrote this small computer algorithm, which ended up creating a very simplified way of transferring files. And once he did that, it was extremely fast. The downloading process became extremely fast, right? So what happens in this small program that he wrote? Let's say this is a supercomputer and there are 100 user computers all around the world. Now, if you download Sean's program, the program he made, this program will take any file, some media file, it will create a small dynamic directory of that file, and it makes it conducive for transfer, and you can share it with multiple people. Okay, and the server computer has to be active, right? There has to be a server, and only when the server computer is live, you can access it and download files from it. All that is technical knowledge. This is called P2P model, where you access data from another computer in a direct connection. Okay, so is this copyright infringement? Yes. Okay, and what did the court say? The courts also said, yes, it is copyright infringement. And since Pierce has made this dynamic directory, even though he's not directly infringing it, Sean Fanning did not directly download the songs, right? But he enabled the whole system. He provided this whole program to the other primary infringers. So is he a secondary infringer? Yes, he's a secondary this is secondary contributory infringement. Why? Because does he have knowledge? Yes. Constructive or active knowledge doesn't matter. He did have constructive knowledge, right? Yes. Was this substantial participation? Yes, because he created the whole interface for them. So what did the court say? The court held that willful knowledge is constructive knowledge, and Napster was shut down. His company was closed down. It was held that it was secondary infringement. Now what happened after this? A new system came up. The second generation of P2P model happened, where what did Sean Fanning do? He invented a dynamic directory, right? The second generation of P2P models did not have this dynamic directory at all. They found a different methodology of downloading and transferring files. So now what happened? Now this case happened, MGM Studios versus Grokster. In this case, even though they went to court, the P2P community said that, look, there is no dynamic directory over here. And the P2P sharing community is jumping in joy because the court cannot do anything, right? The court cannot prove that there was substantial participation because there is no direct directory that is there. So what did the court do? The court held that there was a willful purpose to encourage others to commit copyright infringement. So therefore, it is the third type. What is the first one? Contributory infringement. Second type is vicarious infringement. Third one, inducement liability, inducement infringement, right? So since, even though there was no substantial participation, it was not contributory, it was not vicarious, they induced and they willfully encouraged others to commit the infringement. Therefore, it was inducement liability and they were held liable. Okay. So why this case is important is it establishes the third concept, inducement liability. That's all. And in Columbia Pictures versus Fung, it said it applied the same concept. It's a continuation of the Grokster case. It again reiterated the points. It said that it re-established the inducement theory of copyright. In case it does not fall into contributory or vicarious infringement, it will fall in the inducement infringement, where you induce the person, where you willfully encourage them to infringe copyright. Okay, and then this is just one more concept that he just explained. Let's just go through it. It's something separate. Okay, it's not related to infringement. It's not related to inducement infringement and the P2P sharing model. Any doubts in P2P? Moving on. Anil and Purushottam jointly write a novel, right? So they're joint authors and they're joint owners, right? Mr. Samrat asks for publication rights. He wants to publish the novel. Now, Anil and Purushottam have a dispute. They say, look, I don't want to go with Samrat. I want to go with Ajinkya. Anil says, no, let's not go with Ajinkya. Let's go with Samrat. So now there are contradictory opinions. Whom will you go with now? Whom will they publish it to? Now, Anil, can he individually grant a license to Samrat without the concurrence of Purushottam? He can do it. Okay, but he cannot grant an exclusive license. He can only give a normal license. And whatever royalty he makes as part of that license has to be shared between the two of them. So it is possible for only one author to grant a non-exclusive license. And if both agree, then an exclusive license can be granted. But even if only one author is granting the license, the royalty still has to be shared between both of them. This is the next concept. Next, we come to the final concept, okay? Fair deal doctrine. Oh, we are almost done, man. Thank God. Surprisingly, we are almost done. Any doubts? Let's take a 5-minute break and start again. Yeah, how's everyone following, man? Is it getting clear? Someone answer. Ajinkya, Shriari. I'm back.
Hello? Yes, yes.
Yeah, it's a very
Listening,
horrible
yeah.
subject, I'll tell you, because the third part of copyright has been terrible. Like going through the notes, the lectures, it's been horrible, really. Coming to the last concept today, fair use doctrine. Okay, do you remember from second test? Let's go there only. Let's do a quick recap of what was there. Yeah. So the author has rights, right? Under section 14. Can the rights be curtailed by the government? Answer is yes. If it follows all the three conditions stated in the three conventions. What are the three conditions? It has to be a special case. It does not interfere with the normal exploitation of the work, and it must not unduly prejudice the author. So if these three conditions are followed, then you can put curbs on the author's rights. So there are 5 places where the Indian Copyright Act has put curbs on the author. First one is the first sale doctrine. Once the author has sold a book, his rights are extinguished. I can resale the book. The right of resale does not exist to the author. So don't you feel it's a curb on the book? Right? Is it a special case? Yes. Does it unduly prejudice him? No, because he's already got his royalty. Does it interfere with the normal exploitation of the work? No, it does not, because he can resell the book. He can sell the book in other ways, right? So first sale doctrine is the first place where it has been curtailed. Second one, the limited period of duration of the copyright protection. How long does copyright last? 60 years following the death of the author, right? But why can't I have it forever? So this time limit that has been set, is that also not a curb on the author's rights? But does it unduly prejudice the author? No, because he's enjoying it for such a long time. Does it interfere with the normal exploitation? No. Is it a special case? Yes, because obviously you cannot have it for such a long time, or more than 200 years. Third one, compulsory licensing, which we studied last time under section 31A, where if the author refuses to give a license, you can take him to court and force him to give a license. Again, it has to follow all the 3 criteria that we listed, right? So compulsory licensing. Next, statutory license, where you don't have to take him to court, where the transaction cost is low, where you pay a royalty and you automatically get a license, right? That is statutory license. And the last one that we're going to see, that we're going to cover today, is fair deal doctrine, where the author, and what is the jurisprudence, what is the logic behind fair deal doctrine, where you directly take somebody's book and you copy it, right? If it comes under the fair deal doctrine, it's not illegal. So what is the logic behind this? The author, anybody who writes a book or a poem, he has enjoyed the fruits of society, correct? Without society, what book will he write? He has enjoyed the fruits of society. All the contribution of my ancestors, them building roads, internet, books, it is because of them, because I stood on the shoulders of my predecessors. Therefore, I must also support my successors. I must allow them to stand on my shoulders. Okay, so this is the concept of fair deal doctrine, where since I've taken so much, the fruits of the labor of the past, I need to pass on the fruits of the labor of the present to the future. But all these have to be done by following the 3 criteria again, where it does not prejudice interest, where it does not interfere with normal exploitation, and it has to be a special case. This is the concept of fair deal doctrine. So coming back to where we were, fair deal doctrine. Whew. P2P we finished. Yeah. So fair deal doctrine. Yeah, the fair dealing doctrine has to comply with the 3 conditions of the conventions. Just now we discussed. So the infringer has obviously copied. He has definitely copied now. And fair deal doctrine gives permission for copying under law. It allows it. It legalizes the copying. So CCH case, it's there in the PPT. What was this case? There was a library and they allowed all the users to photocopy cases, case laws that we study, right? In these law directories, they were allowing their users to take photocopies of these cases and go home. And the law journals filed a case saying that, how can you allow this? If you allow photocopies, nobody will come and purchase the directory from us. Like SCC, Manupatra, they file a case against CCH. And what did the court say? The court held it as fair use. Let's just quickly go here. I think it gives a very beautiful summary of the whole case. Yeah, CCH Canada. So group of publishers sue the Law Society of Upper Canada for copyright infringement for providing photocopy services to the researchers. So do law reporters like SCC and Manupatra, do they have copyright protection? What do the Canadian Supreme Court say? They established the non-trivial, non-mechanical skill and judgment modicum of determining. And what do the courts say? The court held that law reports are copyright protectable, but only up to their own modifications. And it held that the Law Society's practice did not infringe copyright and fell within the bounds of fair dealing. It comes under the fair dealing doctrine. So this is the case that you have to quote for fair dealing doctrine. And What happened now? Yeah, and the court also said this. It said that don't think the fair use doctrine is just a defense. Let's say you've lost your case, copyright infringement case, then you don't claim fair dealing as a defense. Use it as a positive right. Use it to assert your right. Okay. And again, sir reiterated this concept where even in science, Newton says that I'm Newton only because of all the work of my predecessors. So since you're stood on the shoulders of all your predecessors, it is your duty to pass on the fruits of your labor to the to your successors. That is the jurisprudence behind copyright law. So in America, it's called a fair use doctrine. In India, it is called the fair dealing doctrine. It means pretty much the same thing. So how can you enforce? Like, how do you write down the rules of the fair use doctrine or the fair dealing doctrine? Either you lay down a standard as to what might be fair use or fair dealing. You just put a set bland rule, like a blanket rule, or you can give a case by case specific rule, right? A specific case by case parameter to determine whether it's a fair deal or not. So in US, a standard has been laid down, just the concept as to what could be fair dealing doctrine, fair use doctrine, and the judiciary interprets it. Each case it decides it. But in India, concrete specific case by case rules have been laid down.
Vishnu? Like sir did not share the.
He has not shared it. So what is the difference? So IIT puts a rule. Do not drive very fast in IIT campus. Is this a specific rule or is this just a standard that has been laid down? It's a standard, right? Just don't drive too fast. Second one, do not drive over 30 kilometers per hour in the campus. That is a specific rule. So in the US, there's a standard laid down. There's no specific rule. In India, there is a specific rule that has been laid down. Okay. It is very difficult to determine whether the court would determine something as fair use or not, right? You don't know. So let's say I want to infringe a work. Bhuvan has written a novel. I want to copy the novel, but I go to Bhuvan for a license and Bhuvan charges me 5 crores. I tell Bhuvan, what is this, Bhuvan? I don't want to pay that license. I'll claim this as fair deal doctrine and I'll publish this work myself. Now it will go to court, right? The case will go to court. And now the court will decide whether it comes under fair deal or not, after all its test and comparison and all that. Do I need this risk now? No, because if the court holds it as infringement, I'm pretty screwed now. If it holds it as fair use, well and good, all fine. But in order for me to not get that risk, to not be under that stress, it is always better to preemptively obtain a license. That is the concept. Okay, don't put yourself under that risk. It might be considered fair use, but since there's so much power on the court's discretion, don't take that chance. It's just legal advice that SM gave. Okay. Moving on, section 52(1)(a) talks about fair dealing doctrine. Let's not even go through that section. The section is complete nonsense. So much of legal jargon, it doesn't convey anything. So it establishes 4 tests. And if all these 4 tests are established, then it comes under the fair dealing doctrine. First one is purpose and character of use, nature of the copyrighted work, amount and substantiality of the portion used, as in how much has been copied, and effect on the potential market. Let's see what each one means. Purpose and character of use. So is there sufficient transformation of the work? What does this mean? I'll give 2 examples, okay? There was a book actually that was written long back, Catcher in the Rye, and a new author came up. He went to the original author and he said, look, I want to write a sequel to your work. Okay, I want to continue the story. And he asked for permission from the author. Can you give me permission to write a sequel? Author says, no, I don't want to give you permission. I want the story to end here. But this guy, second guy, he writes the sequel and the whole sequel continues 60 years later. It's not, don't mistake it for 60 years after the copyright subsists and all that. He writes a novel. He continues the novel 60 years later from what happened. And one of the characters from the previous novel was exactly the same over here because it's a continuation, right, of the story. It was held that he claimed, the case went to court, right? The original author said that he has copyright infringed. So what did that author say? The second one said that there is fair deal doctrine applies here. Okay, fair use, it is fair use. But the court said that there was not enough substantial transformation. You have not transformed the work, you have done direct copying. So an injunction was granted and he was stopped from selling the work. Let's take another example, you'll understand it. Ajmal writes a maths textbook, okay? 100,000 problems he makes. A Delhi publisher, they write a solution book with all the answers. So now, is this sufficient substantial transformation? Yes. Okay. Were all the questions copied? Yes. Even this was true, right? Even though they have copied, even though they have copied, they've committed the infringement. Since there was sufficient transformation, the answer is yes. The fair dealing doctrine applies. Why? What is the jurisprudence? The solution book does not affect the sale of the actual textbook. Because what sir said, I don't agree with sir. What Matilal sir said is, if you're a parent and you want your son to study for an exam, will you buy him the solution book or the maths textbook? And only if he's unable to solve the math textbook, will you give him the solution book? I disagree with it, because I feel all the questions are already there in the solution book. You'll be a dumbass, right? If you're going to only buy this question paper. So what Sir said is, there has to be sufficient substantial transformation. Okay, and there was a case, Masters and Chancellors of Oxford University Press was a Narendra publication house. Same thing. A maths textbook was written, publisher wrote the solution book, and the court held that it was fair use because sufficient substantial transformation had occurred. Okay, so this has to happen. Second one, nature of the copyright work. It depends on this. Why? Tell me.
Vishnu,
Yeah.
like for every, like I make a reaction YouTube video, then how will you fit this transformation test?
A reaction YouTube video. Again, wait, let's finish all the conditions, you'll understand it. Okay, because degree of copying matters. How much you have taken from the video. Second one, nature of the copyright work also matters. Like you said, YouTube video, right? Don't you think the standard has to be different for a YouTube video, different for a maths textbook, different for a work of fiction? Because a piece of fiction like Harry Potter, it's a highly creative work. And it's very, very hard to make a case of fair deal, right? Because how can I say that fair deal doctrine will apply? Because I'm copying a creative work. But if it is a factual book, a book about facts, about an event, some historical event. I'm writing about the War of Ashoka, Kalinga War. It's about an event, right? In that case, the fair use determination is very high. It's very easy to establish it because of the nature of the work. If it's a work of fiction, very difficult to prove. If it is a factual work, if it is something non-fiction, it is possible to do it. So the nature of the work is important. So there was a book that was written, okay, about the Kennedy assassination. The President Kennedy of the US, he was assassinated, right? And somebody wrote a book, and somebody again wrote another book about it, and it was very similar. Obviously, right? How many versions can you write? So the court held that it was a historical work and it was a factual work, and the court held that it was fair use. Okay, and there was one more case. This was the case about the Kennedy assassination. Time Incorporated versus Burnett, guys. Third one, amount and substantiality of the portion used. Let's say I take a work, I take somebody's book, I copy 90% of it. I've copied 90% of the work. Calculating what percent of the original work was incorporated in the new work. Okay, after comparing the two works. And listen to this case. Harper and Row versus Nation Enterprises. So in this case, the president, listen to this very carefully, okay, because there are two contradictory cases. They're not contradictory. They cover both the opposite concepts, both the symmetrical concepts. So a case was filed, okay. The president of America, Gerald Ford, he had written a book. Gerald Ford wrote a book about why he pardoned the previous president. Richard Nixon had waged a war against Vietnam. And when Gerald Ford became the president, he pardoned Nixon. So he wrote a book about it. Okay. And then the defendant, the Nation, as in this newspaper or this magazine, they wrote a similar book. They wrote an article and they quoted 300 words from this book. Just 300 words. Nothing substantial. Only 300 words from that book was copied. And the Nation, when Gerald Ford, the publisher, they filed a suit, the Nation asserted that its use of the book was protected under the doctrine of fair use because it was a historical account. They said, first thing they said was Gerald Ford is a historical figure because he's a president, right? And it's his account of a historical event about the war, about the Vietnam War. So they said that it has to come under fair dealing doctrine. And they said they've copied only 300 words. It's not something substantial also. But the court rejected this argument, holding that the right of first publication was important enough to find. And I'll just tell you why. Even though the amount copied is very less, the amount does not matter in this case. In this case, even though the amount was only 300 words, what mattered was the material that was copied. They had copied the golden nugget of the work, as in the most important portion of the work was copied. Therefore, fair deal doctrine does not apply. Because if I can read that article and I get the climax of the novel in that article, why will I read the novel again? The whole golden nugget of the work was in that article. So therefore, fair use doctrine does not apply. It was copyright infringement. Now listen to this case. Kelly versus Aribasoft Corporation. He took a photograph. There was a photograph, okay? A very beautiful photograph of some nature, let's say mountains. Now, one infringer, the defendant, he had a computer program and he used that photograph as a thumbnail in the icon of that program. He used a very low resolution version, right? Thumbnails are not high resolution. And the only difference is the resolution was lower than the original photograph. It's the same photograph. And in this case, there were only 300 words taken, right? But here, 100% of the thing has been infringed. The percentage of, what did I tell you? It's important to see how much, what percentage was copied, right? Here, 100% has been taken. And in that case, only 300 words was considered as copyright infringement. But in this case, the court held that even though there was 100% copying, it was not copyright infringement. It's absurd. It's very absurd. In that case, it said even 300 words was enough. Here it's saying 100% was not enough. Why? Listen to the argument. Court held no infringement because anyone that understood the artistic, aesthetic merit of a photograph would visit the actual photograph's website. Okay. I'm using the computer program to use the computer program. Fine. The thumbnail has attracted me, all that fine, well and good. But the thumbnail had such a low resolution. And for someone to derive the aesthetic, artistic merit of that photograph, I'll have to actually go to the actual photograph and not the thumbnail. Therefore, this was not infringement. Okay. So tomorrow, based on the question that comes, where there is infringement, you quote this case, Harper's case. If where there is no infringement, where it is not an infringement, you quote the Ariba case. Okay. Coming to the last concept, potential effect on the market. This is the last one. I'll summarize all of them. Okay. This is also interesting. Pierce writes a novel. Okay. He does not make it into a movie. 10 years have gone by. He's not made a movie. He's only written the novel. But the movie market, is that not a market for Pierce? It is a potential market for Pierce, correct? Because he can always make a movie and collect money from it, right? So it is a potential market. So there are two types of market: the primary visible market, as in the market, the novels market, the book market. Second one, the invisible potential market, the market that has not been tapped into, that I might tap into later on. And this is the first case that comes up: Rogers versus Coons. Okay, so Rogers, he clicked a photograph of these guys. He has the copyright over this photograph of these dogs. And then Mr. Coons comes up and he makes a sculpture of the whole thing, and he recreates the photograph. So now Rogers, what the argument was made was, Rogers has the 2D market, correct? Photographs are in 2D, and the 3D potential 3D market does not belong to Rogers. Okay, it belongs to the sculptor. But what did the court say? The court said that even though the 2D market belongs to him, the 3D market is a potential market, and it will always remain with the author of the work. And the right to translate the picture to a 3D model remains with the author. Coons has violated copyright. Okay, and the actual case goes into more things, where Coons actually says that it's not a direct copy, it's actually a satire, a parody, and it falls under the parody exception of copyright, because parodies don't come under copyright infringement. And the court said that fair use does not apply here. Let's see the next case also, Hubbard versus Wasper. So there's a Church of Scientology, as in they have some kind of pseudoscience, okay, in the US. It's related to the church over there. And there was a member, Mr. Cyril Wasper, and he was a member of the Church of Scientology. And once he quit this group, he published a book. Okay, and in that book called The Mindbenders, he criticized the work of the Church of Scientology. And he copied a lot of the discussions that happened there and many of the documents that he collected over there. And the Church of Scientology alleged that the books contained material copied from the books and documents written by Mr. Ron Hubbard, as in the person who was running that place, and it contained confidential information of the Scientology courses. So this was copyright infringement. But Wasper, he successfully defended the claim under the fair dealing doctrine. Because what did the court say? The court applied the 4-factor test. They asked, was there sufficient transformation? Yeah, agreed. He has copied your work. Agreed. Has he transformed the work? He quoted. Did he quote less? As in, like, did he quote less from your documents and did he supplement more with his own material? Or did he quote more of your work and did he supplement it with less of his original work? I'll just rephrase it. When you read a case law from SEC or Manupatra, there's a head note, right? There's a head note. So they've quoted the original work and they've also supplemented the work with their own material, right? Now, when I obviously copy some work from online, when I make my term paper for CPC, I take some article. I put the reference, right? I quote the reference in the footnote. I quote the article and I supplement it with my own material. So what did the court say? They applied the 4-factor test. Was there sufficient transformation? They said yes. Okay. The book was not the primary or secondary market of the work. Therefore, it was under fair use. Okay. So what did the court say? They said that, yes, he took your work, agreed, but he sufficiently transformed the work. So it comes under fair dealing doctrine. And the court said him writing that criticism book, the book of criticizing the Church of Scientology, he had copied a certain work, right? They said that he had copied certain documents of the Church of Scientology. They said the book was not the primary market. Neither was it the secondary market of the work. Because why? The followers of the Church of Scientology, will they go to buy a secondary book, as in a book criticizing the Church of Scientology? No, right? So it does not come under the primary market. Neither does it come into the secondary market. Therefore, it was a fair use. Okay. So I'll just summarize the 4 tests that are applied. First one is purpose and character of the use. As in, has substantial transformation occurred? I've taken a maths textbook, I've published the solutions. I've substantially transformed it. Second one, nature of the copyright work. Standards are different. For a work of fiction, it's very hard to establish fair dealing doctrine. But for a work of fact, a historical fact like the Kennedy assassination, like Gerald Ford's novel about the Vietnam War, in that case, it's it is possible to establish fair deal doctrine. Amount and substantiality of the portion used. How much have I copied? 10%. Have I copied 90%? How much have I contributed? How much of my own portion have I added to it? Last one, effect on the potential market. Obviously, we all have potential markets, right? I write a novel in Hindi, okay? Me translating and writing that novel and publishing it in China, in Chinese, is that not a potential market for me? It is, right? I might someday go to China, rewrite the book in Chinese and publish it there. So that is my potential market. So that also comes into play. So if all these conditions are examined, and if the work fulfills all the conditions listed under this, and if it fulfills the 4-factor test, it comes under the fair dealing doctrine. Okay, coming to the last concept.
After this, answer to Sri Hari's question.
Yeah.
Where he said that would the reaction video need to comprise infringement or not? I would argue not, going by the thumbnail case.
Yes.
That people will still go to the original video.
Exactly. Sri Hari, I'll tell you what Bohan just told you, okay? Answering Sri Hari's question, what did Sri Hari say? Suppose I make a reaction video, some dance video is there, or some video of a debate, Sai Deepak's debate is there. I make a reaction video on it. And I take clips and then I react to it, right? That's how a reaction video is made. So why does it come under fair use doctrine? Why? First reason, what did the thumbnail case establish? Even though people watch it over here, for them to get the actual material, they will go to the actual video itself, right? That is the first thing. Second one, don't you feel there has been substantial transformation that has occurred? I've taken the actual work, I've added my own content to it, I've transformed the work. Therefore, it comes under fair use doctrine. So even reaction videos will come under this. But since it again depends on the nature of the work, it depends on the court, how the court interprets the case. Okay, so according to my knowledge, it should come under the fair deal doctrine. Even the next concept applies. The third one, how much of the work have I copied? 90%, 10%. I can't obviously play the whole video in my video, right? I just take clips, all the important portions, all the highlights I take and I react to it. Okay, this is the last one, okay? Just one paragraph left. And even I didn't understand this, so even you're not going to understand it, I'm sure. Section 51A2, okay? Again, we already discussed this. Permits for profit any place. As in, I am the owner, dance hall owner, right? I own this dance hall. I allow the place to be used by this copyright infringing person to come and deliver his performance. So that's what section 51A2 talks. And Super Cassettes was a MySpace is a case that happened in India. I know it sounds like a foreign case. And in this case, it established that this term place can also include virtual spaces. What does this mean? I run a restaurant and I allow a band to come and perform. And they have, yeah.
Sorry, like which section you are covering? Like 51?
A2, section 51. We already covered it, man. Section 51 talks about all the types of infringement. And section 51A2 talks about secondary infringement, where if I'm permitting profit for any place, I own a restaurant, I've allowed a band to perform, and I have the direct ability to control, and I'm deriving a profit. So what does it come under? Vicarious liability, correct? Vicarious infringement of copyright under secondary jurisprudence, secondary infringement of copyright. So in this case, Super Cassettes was a MySpace. It said that even virtual spaces come under this place. It doesn't have to be a physical place. I have a restaurant, I'm allowing it. Yeah, it is secondary infringement. Suppose I'm running a website. I'm running MySpace. It's a social media site. In that, the infringement is happening. Does it also come under place? Yes. Places includes virtual spaces. So MySpace is a social networking site. T-Series found out that a lot of their songs were being shared on MySpace. And what did MySpace say? We cannot be held liable. They said that, firstly, section 51A2, it's not a physical place. So section 51A2 can't apply. They said it's not a physical space, it's a virtual space. Court reversed it. Court said that it includes virtual spaces. Second one, what did MySpace say? They said that the Information Technology Act says that the intermediary cannot be held liable. As in the person who has made the website, any intermediate website, the middleman will not be held liable. But the court held that in the matter of copyright infringement, liability is strict and absolute. There is no excuse for the intermediary. They will be held liable for secondary infringement. Okay, two things. First one, place includes virtual spaces. Second one, they established that even though IT Act excuses intermediaries, in the matter of copyright infringement, it does not occur. There is no excuse. They will be held liable. This is the case. Tomorrow, if it comes, you can find the link. Then he went into one more case, Lange versus Universal Pictures, where don't you make all these TikTok videos, right? You take a song, you dance to it, and then you upload it online. Can T-Series come and ask for infringement? Because you're playing their song there. Again, Sri Hari's argument comes in. And again, the thumbnail case comes in, where people who come to listen to the song, to watch a video, are they coming to watch a video or listen to the song? if they want to listen to the song, won't they go to the actual song itself? Right? So again, the court held the same thing, where it said that it comes under fair use. Why? Because people have come to the video to watch the video, to watch the dance, watch that person's dance. And if they want to listen to your song, they will come to the actual source of the song itself. So this is what Lange Universal Pictures established. Done, man. Any doubts? It was very abstract and unstructured, I'll tell you. I'm very sorry. Even I hate presentations like this. Any doubts?
Vishnu, can you just open paper last I shared in chat?
Where have you shared it?
Why there is dark behind you means like in day?
Somebody has actually stuck black KG cardboard behind.
Okay. Yes. I thought there is night in Kolkata.
Night in Kolkata, it seems. So go on. In MMM hall in this room, it's night time. Okay. Can you see my screen? No, I'm not sharing my screen. How many of you are listening, man? Adarsh, I'll ask you doubts. Are you there, Adarsh? I'll ask you a question now. Unmute your mic, Adarsh. I'm going to ask questions. Adarsh P. Are you listening or not?
Yeah, yes.
I'll ask you a question now. What are the two types? What are the two types of secondary infringement we covered today? Two types we covered. There are three types we covered. Fine, you tell two types enough.
I'm not remembering.
Not remembering.
Indirect inducement, vicarious.
Contributory, vicarious, and inducement. Three types. Not listening, others. Now, though, you've landed yourself in a very problematic situation.
How to get out of it?
What do we do? How to get out of it?
Any idea?
Okay, sharing my screen. Let's go to the question. Right? All of you are there, right? Let's read the question now. During the early half of 2019, Mr. Oliver Atkinson, once again, a renowned English poet, composed a poem. Pay attention, okay? All of you are sleeping. Wake up, because his questions cover every single concept. A renowned English poet composed a poem hereinafter referred to as poem on June 1st, 2019. Okay? Mr. Atkinson's publisher published the poem in a book form containing a large explanatory preface from the poet. Well and good. The book contained the poem, was released simultaneously throughout the whole world. The entire world has released the book. The book was an instant hit. What is the first thing that comes to your mind? First one, remember what I told with Sharat's case, where if the book has moderate access, and it's very hard to prove the degree of access, it's going to be very hard for you to prove the case in court. Very hard to prove the infringement. But here it's saying that the book was an instant hit. That means the degree of access is very high because more people have read it. So there's a higher degree of proving copyright infringement. And featured in the top 10 of the best-selling list of books, various leading dailies and e-commerce websites. Fine. The text of the poem is produced below. Again, he's written the same poem. Okay. So he has got this poem last year itself then. Okay. So on January 1st, 2020, an authorized French translation of the poem number 1 was published. The translation 2 made it into the top 10 of the best-selling books. So 1 year later, somebody has rewritten it in French. It was authorized. Okay. He has given the license. The author has given the license for the French translation. It has been published. It has come in the top 10 of the books selling in France and other places. So it's a very beautiful poem. August 5th, 2020, Mr. Fernando Sanchez, a promising young poet, published the poem in Spanish. Okay, this is not authorized. It has not been authorized. During his childhood, Mr. Sanchez came down to India with his parents and took Indian citizenship. He lives in Mussoorie, Uttarakhand, India. Apart from Spanish, he is fluent in Hindi and French. What does this tell you now? Now that I've established French, do you not remember Michael Bolton's case where the RJ came and said that he had played the song during his childhood? But here it was a low degree of access, correct? And Michael Bolton himself came and got himself screwed. Okay, him knowing French, do you not think it is a low degree of access? Okay, so it's not enough to prove it. Let's see what else happened. But he cannot read and write in English. So he cannot read the first poem that was released. In the start, it was released in English, right? Mr. Atkinson's poem was released in English all throughout the world. He cannot read or write in English, fine. But he knows French. What kind of a guy, man? He doesn't know English and he knows French. Okay. Yeah. So on January 1st, 2021. Oh, look at this, man. The poems reproduced here are composed by my esteemed colleague, Professor Anvay Mukhopadhyay, Department of Humanities and Social Science, IIT Kharagpur. And they are copyright protected. Okay. Yeah. So my sincere thanks to him for his kind gesture of composing the poems at my request. So me reading this poem to you guys, that is also copyright infringement, okay? But do you not feel it comes under fair deal doctrine? Why does it come under fair deal doctrine? Can anyone tell me? Why it comes under fair deal doctrine?
Educational purpose.
Comes under educational purposes. Correct. Because since Mr. Mukhopadhyay has stood on the shoulders of his predecessors, should he not allow us also to stand on his shoulders as being students of law? So it comes under the fair deal doctrine. Use all these words in your answer tomorrow, sir will be happy. So in 2021, Mr. Sunil Sen translated Mr. Sanchez's poem into English after obtaining due authorization. Okay. Understand this. Sanchez has published the work in Spanish. So first one, Atkinson has published it in English. He has given permission to publish it in French. Okay. So this poem has been written in English and French. Now Sanchez has written a poem in Spanish and he has given a permission to someone else, right? To Mr. Sunil Sen to translate it into English. And now he has written the other poem, the second poem that we studied. But it's very similar. Have you played Chinese Whisper? Like I give a message to Ajinkya, Ajinkya tells the message to Anirban, Anirban tells the message to Akanksha. And then finally, we both have something similar. It's not the same, but something very similar. There, English to French happened. Here, Spanish to English has happened. Let's see what the connection is. So in her review of poem number 2, published in Literary Days on February 5th, 2021, Professor Smita, a renowned expert, as in a generalist judge, cannot pass a verdict, correct? A specialist has to pass a verdict. Look at how all the concepts are coming together. On comparative literature, commented that the poem reminded her of Mr. Atkinson's poem, blah, 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 blah. Perfect. And Mr. Tripathi actually quotes the lines of the poem and he says that it is similar. So what is the question? Very simple, na? After reading the review of Professor Tripathi, Mr. Oliver Atkinson, the English poet, and his publisher instituted a copyright infringement suit against Mr. Fernando Sanchez, first defendant. Second defendant, Mr. Sunil Sen. Third defendant, Mr. Sanchez's publisher. And fourth defendant, Mr. Sen's publisher. As in, the Spanish writer, the Spanish publisher, the English author, and the English publisher. And you are the judge now. Write a judgment after giving a detailed step-by-step infringement analysis. Exclude the fair dealing doctrine in this case. Okay. I think the answer to this is the answer that we gave for the first test, right? It's the exact answer, abstractions test. You need to apply the abstractions test and then determine what part of it was the copyrightable nectar and how much of it was copyrighted, right? How much of it was copied. If you guys want, I'll show you the answer that I wrote for the first one. Let's go to the question.
Comprehensive, like it will be comprehensive literal copying or fragmented means what?
It's
comprehensive
fragmented. It's fragmented, non-literal copying.
Fragmented.
Throw literal out of the head, okay? Literal means it is exact copy, exact word by word. It's not literal. He has changed all the words. See, Harry Potter has become Harish Salve here. As in, instead of I was blessed with no death, over here it was
Immortality.
So it is comprehensive non-literal copying, I think. Then
it is comprehensive non-literal copying. Exactly. Yes.
But
okay.
We did not write it in first test, Vishnu.
You have not written it. I have written it. I'm getting full marks. Moving on. Mr. Fernando Sanchez filed a copyright infringement suit against Professor Smita Tripathi. Why did he file it against Professor Tripathi, man? Yeah. What do I say? Okay. So what did Professor Smita Tripathi do? She published a review, right? What did she do? In her review of the poem, number 2, she has made a review of it. Professor Smita Tripathi took the poem and she wrote about it, right? So let's see if fair deal doctrine and all that nonsense comes here now. So Sanchez, he files a copyright infringement suit against Professor Tripathi for making the review now. And again, it comes back to Srihari's question of making a reaction video. And it goes back to the thumbnail. Would that constitute enough? Don't you think people who read the review will actually go and read the actual poem itself? Would you just read the review? Don't you think an actual enthusiast, a poem enthusiast will go and read the actual poem? Let's see now. Claiming that reproducing and circulating a part of the poem, number 2, constituted infringement. So can Professor Smita Tripathi and the owner of Literary Days take shelter under the fair dealing doctrine? Discuss analyzing the 4-factor test. Okay, let us apply the 4-factor test here now. Where is the 4-factor test?
Only reproduced a part of the poem. She didn't reproduce
only a small portion of the film. But even then,
also transformed substance.
Yeah. Okay, I'll give you the 4 tests now. 4-factor test. Purpose and character of did she substantially transform the poem? Yes. Why? She copied a portion of the poem, first of all, only a small portion of it, and she gave her own contribution to it. Right? She added her own input, her own understanding of the poem, and she criticized the poem. She's the one who's analyzed, right? How it was similar, and she said that it sounds similar to this other work. What was the nature of the copyrighted work? Was it a work of fiction? Yes, it is a creative work, right? So it is very hard to establish that it was fair dealing doctrine can apply here because it is not a historical event, right? It is not a historical fact. It's a creative work. So the second test, the second factor works against Professor Smita. It's very hard to establish fair deal under the second factor. Third one, the amount and substantiality of the portion used. I just told you, right? The amount does not matter, whether it is 300 words, just 300 words, or 100% of the copying, as in the thumbnail. The amount does not really matter, but the substantiality of the portion used, because even though she did take a small portion of it, she did substantially transform it. Okay. And what is the effect on the potential market? Do you think people who have come to read Sanchez's poem will read that review of it and be happy with it? Of course not, right? Suppose I watch the review, a reaction video of a movie, a film review on YouTube. If I really liked it, if I have come to watch the film, will I not go and watch the film? So does it affect the potential market of the poet? It does not, right? So it fulfills the four factors. Even though the second one, it's very hard to establish the second factor, the other three factors are established, right? So
Vishnu,
yeah.
don't you think like she's criticizing the poem, so it is affecting the market of the person? Like if I review a movie on YouTube and I say it is not a good movie to watch, okay, I give these criteria. This is, you shouldn't waste your money. A lot of people will abstain going to watch that movie. Don't you think that way? Isn't it affecting the business of that person?
You're right. I think you're perfectly right. Okay. I'll just reiterate the performer's right also. Remember, performers have two rights: right to parenthood and right against mutilation. And right against mutilation is where you take their work and then spin it in such a toxic way that it affects them prejudicially, right? So if you want to bring this dimension, you could try and bring this dimension, but
like,
again, we're not talking about.
It was just criticism. It was not a mutilation of the work. It was a criticism.
No. Yeah. Again, that whole concept does not apply here because it applies only to performers. Here it is a poet. But why I gave you this is, you can apply the jurisprudence here. The philosophy that came there, just try, if you can build a case using that, try and build it here. But regarding what you directly said, where it is criticizing the work. In this case, it was not a criticizement. Okay? It was not a critic. It was not criticizing the work, because in her review of the poem number 2 published in Literary Days, Professor Smitha, expert on comparative literature, commented that the poem reminded her of Mr. Atkinson's poem. Would this constitute blatant criticism?
It was not value loaded. It was not value loaded.
It was not.
Isn't it a criticism? Like if I say I copied the Vision newspaper, it's my criticism of knowledge.
Okay, there are two cases. Okay, first one where Professor Smitha only commented that it reminded her. In that case, if it only reminded her, I don't think there's a substantial link. It is not criticism. Okay. Second one, where every line she has criticized, where she has said the poem is horrible, it is disgusting, it was an exact word by word copy, then the poet can file under tort law. He can get a civil remedy under her for defamation, not under copyright law. Perfect.
Yeah.
Answer for it. Okay, defamation case. That's it, man. This is the answer to the question.
The first one, Vishnu, means the answer should be same like what we wrote for or this one. Like here, sir is asking like copyright infringement, right? In the first exam, we were not aware of that.
Oh, you want to do the abstractions test?
No, I don't want to do it. But only we are supposed to do the same test. Then what different we have to do? Because like here we are discussing infringement.
No. The first question is the same. It's the exact same that we got for the previous test. Exact same. You take the two poems, dissect it, apply the abstractions test, find the copyrightable nectar, see what was matching. Okay. And I actually did it. I'll just show you the answer also. Just 1 minute. I won't be reading it out. I'll just show you the answer.
Okay, we have to do the same only then. Tomorrow.
Same. Exact same, man. Hey, it was first test, not second test. Test 1.
Yes.
Yeah, test 1. Yeah. So I just gave the jurisprudence as in it can't be it has to be non-copying and there has to be some kind of labor skill and judgment. Then I dissected it. Imagine that matches, suppose, made love, where all the matches that happened. So I established that it was a comprehensive non-literal translation first. Comprehensive non-literal translation. Then applying the abstractions test, right? Where's the abstractions test, man? Yeah, the second answer. What were the ideas? The concept of falling in love with fire. Then I established the elements in public domain. Then the things dictated by function. Then the things established by industry standard. Then the scenes affair. Then the merger. Then the facts. And in the end, the very end, what was remaining? What was the golden nectar that was remaining after establishing the thing? So all the concepts that were removed were this. Okay. So after applying the test, the golden nectar that remains after filtration is this. The cursing of the seas to cause them to vaporize and dry up. Okay, so this was the copyrightable material. And since this was exactly copied, since the cursing of the seas to cause them to vaporize and dry up, what was it written as in the poem? Something very similar. Instead of curse, he had put anathema. Instead of seas, he had put oceans. And instead of vaporize, he had put turn into steam or something like that. Okay, dried up, completely dried up. So it was a comprehensive non-literal copying of the copyrightable material. So after applying the abstractions test, I got the copyrightable material. And then I established that it was a comprehensive non-literal translation of this, non-literal copying of this. Therefore, the poem was copyrighted. The expression will be copyright protected in this entire poem. Any other work that has a non-literal copy of this expression of casting a spell on the ocean to dry it up would be considered as copying.
Vishnu, but my question is like what sir has taught, like after like what infringement he might have taught something different, like then what is point of like teaching infringement only? Then we are doing the same that as we did in the first test.
Yeah, but he's not asked, no? What is the question he has asked here? In this question he has asked, what did he ask, man? 1 second.
Then only we have to study fair dealing. Then there.
Yeah, I'm back. Wait. Yeah, sharing my screen. 1 second. What did the thing say? The first question asked only this, man. First question asked, yeah. You are the judge. Write a judgment after step-by-step infringement analysis. Okay, so you want to answer the question with respect to contributory infringement, primary infringement. Okay, I got what you said. What Shrihari asked was, we have studied infringement now, right? We have studied infringement now. So why would sir ask this question now? Like, shouldn't our knowledge answer be different now that we have learned infringement? To answer your question, secondary infringement does not come. Wait. Yeah, man. Shrihari, you're a genius, Shrihari. I'll tell you why. Okay, because secondary infringement comes into play here. Okay, let's go step by step. What is the first type of infringement that's happening? Primary infringement, correct? So using the abstractions test, establish that it is a primary infringement. Comprehensive, non-literal copying of the work, right? Sanchez has copied the poem written by Atkinson. Perfect. Is there secondary infringement now? Who did the secondary infringement? Mr. Sunil, right? The publisher. The publisher who's publishing it. Sanchez's publisher is doing the secondary infringement. And what kind of infringement is it? Is it contributory, vicarious, or inducement infringement? Not inducement, throw inducement out of the window. Primary infringement, it's not primary infringement, throw that out of the window. Is it vicarious infringement? Okay. Is the publisher deriving some form of profit? Yes. And what is the second condition for vicarious infringement? Does he have a right and ability to control the publishing? Does he have right and ability? Yes. Is he deriving a profit from it? Yes. Right. He's getting every percentage of royalty from it. Correct, na? So is there a cogent connection between the sale of the book? And second thing, do you not remember in that case where I said there was a high parking fee? They made a lot of money due to the performance, due to many people coming in. Even in this case, the book has been a top 10 book, right? The book has made a substantial amount of money, so much money. So there is a cogent connection between the profit made and the infringement that has occurred. So the publisher will be held under secondary liability infringement. Mr. Fernando Sanchez will be held under primary copyright infringement. And then Mr. Sunil Sen. What is your understanding of Mr. Sunil Sen? Mr. Sunil Sen will come under contributory infringement. Okay.
To put it now, Vishnu.
Sanchez comes under primary. Sunil Sen comes under contributory. And Sanchez, the publisher, he comes under vicarious. Mr. Sen's publisher also comes under vicarious. Both the publishers come under vicarious.
If Sunil is to come under contributory, then you not also analyze Sunil's knowledge.
Okay, so what do you need for contributory infringement? What all does Mr. Sunil need to have? He needs to have knowledge or reason to believe, right? Does he have knowledge? I don't think so. But will he have reason to believe? Do you not think? Okay, it's going to be hard to prove. Okay, it's going to be very hard to establish his knowledge in this case. And what is the second condition that you need for contributory infringement? 1 second. Does anyone remember? You can tell me.
Also, Vishnu, all these are foreign cases. Means what we are referring.
All foreign cases. Yeah. Okay. Yeah, the second condition is there has to be substantial. Where is it, man? Xerox. Yeah, 1 second. Wait. Wait. Yeah. Chart me. Yeah, it's there in the chart. Yeah, 1 second. Yeah, so what do you need for the contributor? You need to have knowledge, hard to prove. But was there substantial participation? Most certainly. So just to give you the final answer is this. Sanchez, primary infringer of copyright, is directly copied abstractions test you can apply. Show that he has copied the Nectar and Gold. Mr. Sunil Sen, contributory secondary copyright infringement. Okay, in that it's going to be hard to establish his knowledge, but he has substantially participated. Mr. Sen and Mr. Sanchez is a publisher. You can prove vicarious. Right? Why? Because they have the right and ability to control. Second one, they have made a substantial profit of it. There has been a cogent connection. This is the answer.
Thank you.
That's it.
Thank you, Vishnu. Can you share document also? Thanks. Thank you.
Yeah, I'll share the document.
Also, can you do this for family law if possible? Means really a request.
Family law, you should give for us, Shriyari.
Yeah.
No, it's only succession we have to show.
All right. See you guys then. It's getting late. Okay. Bye.
Thank you.
See you guys. See you
Thank you so much.